The most important events in 2016 with regards to intellectual property. We have excellent experts from member states of the EU as well as from the United States. The reason we met today is also the greatest reform of copyright law in the recent years, which will be the subject of discussions. We are also going to look for solutions helping to use intellectual property to develop cultural diversity and competitiveness of small and medium enterprises. As you surely know, the conference will be divided into 5 panels. And before we start discussion, let me welcome the Minister of Culture of the Slovak Republic, Mr. Marek Maďarič.
Ďakujem za slovo. Dobré ráno, dámy a páni. Priznám sa, čeliť takému odbornému auditóriu v prípade človeka takých priemerných duševných vlastností, ako som ja, tak to vyvolalo vo mne trému. O to viac, že sa bavíme o duševnom vlastníctve. Stretávame sa naozaj pri príležitosti významného podujatia v rámci slovenského predsedníctva a určite jedného z najdôležitejších podujatí v oblasti duševného vlastníctva. Duševné vlastníctvo je oblasť stále relatívne mladá, oblasť právnej regulácie. Taký je pohľad expertov, právnikov, ale mne ako laikovi sa žiada jednoduchým slovníkom zdôrazniť, že ide o kľúčovú oblasť kultúry, vedy a mnohých oblastí hospodárstva, jednoducho všetkého, kde sa vytvárajú hodnoty duševnou prácou, intelektom, fantáziou, kde sa pracuje s kreativitou a invenciou. Už samotný pojem duševné vlastníctvo napovedá, že to, čo je zdanlivo, neuchopiteľné, nehmotné, čiže myšlienky, idei, nápady, neprichádzajú z neba, ale sú výsledkom duševnej práce a teda sú dielom niekoho a teda sú aj vlastníctvom ich autorov a nositeľov. Zároveň si treba uvedomiť, že ide o obsahy, ktoré majú obrovský potenciál a preto je dôležité na jednej strane ich využitie, čiže dostupnosť, ale súčasne je dôležitá aj ochrana a vymožiteľnosť práv na strane vlastníkov. Obrovským impulzom do sféry duševného vlastníctva vniesli nové technológie, nové spôsoby sprostredkovania a využitia duševného vlastníctva, internet, celkovo digitálne prostredie. To všetko zdynamizovalo nielen produkciu duševného vlastníctva, ale predovšetkým jeho využívanie a v konečnom dôsledku jeho stimulačnú schopnosť pre široké spektrum odvetví, ako je vzdelávanie, veda, kultúra, alebo aj relatívne nové prierezové odvetvie, ako je kreatívna ekonomika. Dá sa teda jednoducho povedať, že oveľa viac než inokedy má duševné vlastníctvo, jeho využitie, jeho sprostredkovanie a ochrana priame dopady na každodenný život ľudí. Hoci si to široká verejnosť neuvedomuje a často žije v predstave, že to, čo niekto vytvorí, vymyslí, čo je nehmotné, je súčasne aj
to believe that what somebody makes up is for free. I may make this a bit too simple, but I'm not an expert, I'm a politician. This is your task to discuss these important topics such as enforceability of intellectual property rights, reform of the trademark law, transferability and territoriality in the context of a single digital world, the European patent system, and other things in this aspect, as well as the simple reality that digital technologies have brought specific situations with impact on previously used legal tools and a number of questions that require changes of our current legal system. The recently published reform of copyright law that was published by the Commission recently provides some importance for our Commission and
ovplyvňujú a spolu vytvárajú. Vám teda nemusím prizvukovať, že podpora inovácií a dostupnosti kreatívneho obsahu naprieč Európskou úniou kľúčovými
support of this field are a key aspect in the support of the strategy of a single digital world. It is also necessary to guarantee a high level of protection of authors and holders of rights. Our presidency wishes to contribute this by starting trilogues and supporting discussions of ministers in the field of the second package in the reform. And therefore, I believe that this conference will provide space for good professional discussions, space to support experience, exchange, and to exchange the best that you have. I wish that you will not only form a vision of protection of intellectual property in a digital world in here, but I wish that you could also formulate specific proposals so that this conference becomes a collective creator of useful intellectual content and intellectual property. Thank you very much.
To the Minister of Culture of the Slovak Republic, ladies and gentlemen, the translation into English should be on the 4th channel. Ladies and gentlemen, now I think it's all right. If not, try to tackle it or ask the organizers. And I would like to give the floor to Mr. Richard Messinger, the President of the Office of the Intellectual Property of the Slovak Republic. Mr. Minister, ladies and gentlemen, dear distinguished guests, I'm glad that you accepted our invitation and came to Bratislava during the Slovak presidency of the Council of the European Union Professional Conference shaping the IP future, which is under the auspices of the President of the Slovak Republic, Mr. Andrej Kiska, is one of the top of the Slovak presidency of the European Council in IP. Copyright law, intellectual property in common conference is a unique occasion for you to discuss jointly about the future of the IP. We are aware of the fact that Europe faces more crises which can be considered like existential ones. At the first sight, it could seem that the intellectual property and intellectual property protection cannot contribute or solve the started issue. But we have to admit that the functioning system of protection of IP is not sufficient to maintain the economic and social prosperity. No modern economy is able to develop and be competitive without legal setting and rules for players. That is what IP is about. In other words, I paraphrase that the general director of the World Organization of IP says that the IP is inevitable, even if not a sufficient condition of economic development based on innovation and creative industry. Ladies and gentlemen, let me on behalf of both organizers of the Offices of Intellectual Property of the Slovak Republic and the Ministry of Culture, I would like to thank to all who contributed to the conference, and thanks to main organizers, the Office of the European Union of Intellectual Property and the Executive Director, as well as the European Commission. At the same time, I'm honored that the invitation was accepted by more experts in the area of intellectual properties. Dear guests, friends of intellectual property, at the same time, I would like to wish to you a pleasant and a nice time, and I hope that we don't see each other for the last time. Thank you very much.
Thank you very much. As has been mentioned by Mr. Messinger, we have Antonio Campinos, the Executive Director of the European Union Intellectual Property Office, and I would like to ask him for a few words.
Minister Macaric, thank you. Been practicing. President Messenger, dear colleagues, ladies and gentlemen, intellectual property is a vitally important component of the modern economy and society. It is therefore both a pleasure and an honor to take part in this international conference on shaping its future, which has been organized as part of the Slovakian presidency of the European Union. IP has rightly been given a high profile within the EU's 2020 priorities for smart, sustainable and inclusive growth. Innovation is the smart part of this agenda. It is what inspires, like Minister said, the creation of new organizations and the revitalization of mature ones. Creativity and invention are part of the EU's answer to the economic crisis and therefore need to be both accessible and protected. The EU IPO is pleased to play its part in this in three main ways. Firstly, the office delivers what we believe to be efficient and effective registration for the very important EU-wide trademark and design rights. Secondly, we support and encourage cooperation and convergence in IP practices within the European Union and in conjunction with the European Commission internationally in order to make it easier for European businesses to use the IP system effectively. We know that different practices in different jurisdictions can be a deterrent, especially for small and medium-sized companies. They act as what economists call negative externalities by adding to costs without offering real benefits. Helping businesses cut through the red tape, sometimes associated with the use of IP, is quite important, since we know from an OECD study that regulatory costs per employee can be 5 times higher for small companies than for larger firms. The third issue that EPO deals with is supporting better understanding of the role of IP for the economy and society, and helping enforcement bodies with information and tools without, of course, getting involved ourselves into operational matters which are the responsibility of others. Given the topic of the conference, the Office's research and information role is the one on which I would like to focus attention today. In partnership with other major agencies and partners who you will hear from today, the UIPO has sought to put the real facts about IP into context in order to define the challenges ahead. Studies covering the economic contribution of IP to the EU, the perception of citizens, and economic costs of infringement form a trilogy that is designed to help communicate the importance of IP rights. The first benchmark study on the economic contribution of IP, which you will recall has been published in 2013 by the EU IPO in partnership with the EPO, has just been updated. The 2016 edition of the study shows that IPR-intensive industry in the EU now support directly or indirectly 38% of jobs and 42% of EU's GDP. And these industries together are responsible for 90% of EU external trade. The updated study also provides evidence that the industries using IP rights intensively have shown more resilience during the financial crisis. They pay higher wages, for example, and this gap has grown since 2013. The Office has also produced a second important study on the perception of citizens, which is now presently being updated. This research showed us a little bit of the dark side of IP rights. While most citizens say they support IP rights and admit there would be even economic chaos without them, they don't always act accordingly. And such attitudes are particularly prevalent among young people. In fact, 50% of young Europeans aged between 15 and 24 years old consider, for instance, that it is acceptable to download copyright-protected content illegally when it is for personal use. The third trend of research builds on the first two by looking at the economic cost of IPR infringements. And this research shows that lack of respect for and misuse of IP right has a very substantial and damaging impact on the income and jobs of legitimate industry, as well as supporting international criminal networks. This trilogy of studies has helped to establish the Office's action plan and highlighted young people and SMEs as priorities for further research. In response, the Office has looked in more depth at what young people think via an IU scoreboard. And this shows that there is a huge need for dialogue at what young people think via this tool. Let's be honest, we are in a race against time. When it comes to influencing a generation of young people on a matter of real importance for their futures and the future of creative endeavor within the European Union. The Office is conscious that attitudes towards IP may differ across the generations and that different forms of outreach need to be developed, including social media. This outreach is complemented by the work on IP in education, which is taking a fresh look at what the Office can do in close collaboration with the European Commission to help national authorities deal with the indifference that young people seem to have in relation to IP and its importance to society. One of the issues that has emerged from this research is that young people think IP rights mainly benefit big businesses, and they do not believe that infringements do any real harm. Likewise, small businesses also often feel that IP rights are not really for them. This perception was shown in a huge study carried out by the Office covering every EU member state and giving nearly 9,000 SMEs the chance to have their voices heard. The SME IP scoreboard resulting from this research highlighted the evidence of under-exploitation of IP rights by SMEs, by showing that only 9% of them protect their intangible assets with registered rights. The SME cite a lack of knowledge and information on IP processes and their benefits, and the perceived complexity and cost of both registration and court procedures. These issues are deterring SMEs from making full use of some very important assets and may be holding back economic growth. This is illustrated by the fact that SMEs owning at least one trademark, patent or design have almost 32% higher revenue per employee than those who don't use IP rights at all. There is not enough time today to describe these results clearly in detail, but I would urge you to check the results on the observatory section of the EU IPO website. This evidence has relevance both at the EU level and the national level, and in many cases illustrates the need for coordinated action. The IPU scoreboard, for example, shows that young Slovakians are digitally literate, but in common with young EU citizens generally, do not hold back from using illegal sources, especially in an environment where the latest video games are not accessible or affordable. The underutilization of IP rights by SMEs also has particular importance in Slovakia, since we know from odd evidence that SME provide more than 70% of jobs and 60% of added value here. Highlighting these results and taking action based on the evidence is therefore vitally important for shaping the future of IP. In conclusion, considerable challenges lie ahead for IP, and the evidence shows that SMEs and young people must be among the major focuses for attention. In this respect, the EU IPO would congratulate the Ministry, the Industrial Property Office of Slovak Republic, and the European Commission, somewhere in the middle of the room, our international partners, users and businesses groups on the efforts being made to find the best solutions for society and the economy. This does not, of course, mean criminalizing our young people, but it should mean cooperating to close any loopholes that organized criminals may find. Many diverse stakeholders, include young people and SMEs, are involved in making the IP system work properly, and it is important that there is a broad consensus on the way the different parts of the system fit together. That is where events like today's conference can really make a difference. Thank you. Thank you for your constructive and cooperative spirit already shown, and the UIPO looks forward to continue to work closely with all stakeholders on these issues in the future. And let me end by wishing you, and particularly the Slovakian government, all success throughout your last weeks of the first ever Slovakian EU presidency, and certainly, dear Minister, not the last one.
Thank you very much, we hope so, and thank you for interesting data. Tak, milí hostia, teraz sa vám
Dear guests, now in the videos you will hear Francis Gurry, the General Director of the WIPO, and he will be followed by Benoit Battistelli, the President of the EPO, and let's have a look at those.
Minister of the Culture of Slovakia, Mr. Lubos Knot, the head of the Slovakian IP office. Distinguished guests, ladies and gentlemen, it's really a great pleasure and a privilege for me to have this opportunity to say a few words on the occasion of this traditional gathering of European leaders in the field of intellectual property on the occasion of the presidency of Slovakia. I'm very sorry and I apologize for not being present personally at the meeting. Unfortunately, it clashes with the meeting, an important meeting in New York of the UN system, which I absolutely must be present. However, I'm delighted to know that I shall be coming to Slovakia in the month of October, and I'm very much looking forward to that event. This meeting, held during the presidencies, the respective presidencies, is an extremely important occasion, I think, for policymakers to get together. I think policymakers all over the world, at all levels, whether national, regional, or multilateral, are challenged, especially in the field of intellectual property, challenged by, first of all, the speed of change in technology. And we see that in many, many fields. If I may, I'll give one example from a completely unrelated field, not completely unrelated, but from the field of automated cars. In Geneva, one of the institutions looks after the convention, the Vienna Convention, which is the main central convention, dealing with responsibility and liability in relation to transportation and in particular cars. The whole of that convention, the whole of the international legal framework is based on the central figure for liability being the driver. And we are all expecting that within 10 years there will be no such person in transportation. It's an example of the changes that we see all the time. And of course, in the intellectual property field, by definition, it's concerned with the new, and we are seeing changes coming that we're challenged as policymakers, I think, to develop quickly enough the appropriate responses. It's also the case that we have to develop those responses living in the reality of very different worlds. So as we develop, for example, the policy response to automated cars, we know that within the continent of Europe there will be on the roads horses and carts at the very same time, not to mention the diversity across the whole world. It's a massive challenge. I think these gatherings, which are extremely rich occasions for exchanges, particularly helpful in assisting us all in facing these responsibilities that are coming up in the future. If I may say, the European Commission has been extremely active, and I would like to applaud its latest efforts in the digital field, and in particular the step taken closer to the ratification of the Marrakesh Treaty for facilitating access to published works by persons who are blind, visually impaired or otherwise print disabled. As you are aware, the Marrakesh Treaty entered into force on September 30 of this year. As I speak now, we have 22 countries that are party to the Marrakesh Treaty. We are absolutely delighted to see the positive step taken by the European Commission in moving the European Union much, much closer to accession. We are very much looking forward to this event. I take the opportunity to wish you all very rich deliberations and a very successful and enjoyable conference. Thank you very much. Minister Marek.
Dear colleagues, a very warm hello to all those present today. I am sorry that I cannot be with you in person on this occasion, but the EPO is represented by our prominent colleague, who you all know very well, Margot Frolinger. On behalf of the EPO, let me say that we are delighted to participate in this event, organized by the Ministry of Culture and the Intellectual Property Office of the Slovak Republic, as well as the European Commission. Before I say a few words on the conference itself, please allow me to extend my congratulations to all those involved with the Slovak Republic's presidency of the European Union these past months. With initiatives such as this, your presidency has ensured that IP remains at the forefront of EU policy. Today, I understand that there are over 150 participants present, including delegates from national patent offices, IP experts from the EU institutions, representatives of law firms and business, to name just a few. In addition, there are numerous participants from universities, business associations, and entrepreneurs. With such wide participation, it is said to be a wonderful event, and I'm sure that all those present will benefit from the engaging discussions that will unfold over the next 2 days on the future of IP. Assessing this subject is essential for ensuring that we continue to develop an intellectual property system that responds to the needs of all those who rely on IP rights, and the many more who will do so in the years to come. But the question of IP in the future also has a wider significance. We know that intellectual property doesn't just boost our prosperity. a strong, well-functioning IP system, and the industries which rely on it actually underpin our very economies to a great degree. Our recently updated study with EU IPO showed that between 2011 and 2013, IPR-intensive industries generated 27.8% of all jobs in the EU, and were themselves responsible for directly employing 60 million people. These industries also generated 42% of the GDP in the EU and was ultimately worth 5.7 trillion euros. These are just a couple of the ways in which patents, copyrights, and trademarks and designs all play a part in weaving the fabric of a prosperous and innovative Europe. Our continent is a hub for innovation. The number of patent applications from Europeans rises year upon year, and there are indications that this will continue in the following years. European countries rank among the most innovative countries in the world in terms of patent applications per inhabitant. Furthermore, we are exporting more patents to other parts of the globe than we are receiving from inventors outside of Europe. Our inventors are filing far more applications in America, Japan, or China than in the EPO is receiving from those countries. Innovation is therefore thriving in Europe, and the question to be answered is how IP can continue to play its prominent role in the future to foster innovation. For the EPO, the answer is clear. It is a strategy it has successfully implemented in the last 6 years: efficiency and quality. It is by controlling our costs, stabilizing our fees, increasing our productivity, and improving our quality that we can better respond to innovation challenges. The results are there. Let me give you a few examples. Our unit cost has reduced from 95 in 2010 to 82 in 2016. We have suppressed a backlog in search and reduced by 1/3 our overall backlog. We are also ranked by the IP professionals first in the world for our quality. Let me conclude by mentioning one of the most significant developments in patents of our time, the unitary patent. With the recent ratification by the Netherlands, 11 countries have now ratified the agreement. A few others, including Italy and Slovenia, are very close to doing so, and we are now within touching distance of the 13 countries required. We hope that Slovakia will be among them soon. It is also clear that the UPP is a subject of much debate following the Brexit referendum. However, we are confident that a political solution can be found between the UK and the other participating member states. We look forward to this as soon as possible, so that unitary patent can enter into force and Europe's innovators can prosper from the advantages it will bring. So I would like to wish you all a very enjoyable time discussing this and other important questions over the next couple of days. Thank you.
Milí hosti,
Dear guests, the chairs up front are empty, so I hope that the minister will take one of the seats. And many of the people are ashamed to sit up front, but don't be. Let's move on to the first panel. We will have 5 panels in these 2 days, and we're going to talk about the enforceability of the intellectual property rights, not only in the digital environment. Protection of intellectual property is very important, but infringement of these rights is causing great damage. The panel will be led by Martin Husovec, the assistant professor from the Tilburg Institute for Law.
and yet it moves. Intellectual property remedies were seen for a long time as something that is stable. And in the last year we're seeing that there are many changes happening in the European but also world landscape. Ladies and gentlemen, I'm very privileged to chair this panel full of stellar speakers, experts, and distinguished guests who are coming from many different countries. But all of them have one thing in common. They're working together daily to improve and rework the IP enforcement framework, whether in their role as judges, practitioners, academics. So please allow me to introduce this panel of distinguished guests. I'd like to start with our keynote speaker. Our keynote will be Mr. Jean Bergavin from the European Commission, who is the head of the unit Growth F5, Intellectual Property and Fight Against Counterfeiting. He originally comes from the United Kingdom and is economist by training. Mr. Bergavin joined the European Commission at the year 1989. So just to put it in a context, that is exactly when the moderator of this panel was 2 years old. This is to say, think how much knowledge and experience he has collected over the years and how much wisdom he can share with us today. Another our panelist is Honorable Mr. Justice Richard Arnold, who is a judge at the High Court of England and Wales in the United Kingdom. Mr. Justice Arnold originally comes also from the United Kingdom, and since he's a judge, he's a lawyer by training. Apart from being the most renowned IP judge in the country, he has this great hobby that some of you probably know about. He has extensive experience in handing down website blocking injunctions, something he will talk about today. Then we have Professor Mr. John Goldman, who is a Loomer Family Professor of Law at the University of Texas, Austin in the United States. Mr. Goldman comes naturally from the United States. He's a well-known and reputed patent law professor, and who is currently seeking refuge from the US elections in the Netherlands. So he's visiting at a Tilburg University, so he's with me for this term, which I'm very happy and privileged to be. Okay, so this is our panel. Before, I'd like to make a few housekeeping announcements. Oh, sorry, yes. Sorry, you see, I apologize. And of course, the most important, Ms. Zuzana Hečko, who is, originally comes from Slovakia, and she used to work for the European Commission for 3 years. And some of you might know her work that she did for the Observatory on Injunctions in particular. And she nowadays works for this very local law firm that you might know, Allen Overy. So that's Zuzana. Okay, so now I can proceed to a few housekeeping announcements. Each of our speakers will be allocated 15 minutes, and I will try to enforce the time constraints. So for this, I prepared these numbers. So I have 5, I have 1, I have 0, and you're not off the hook, I have -1 as well. Okay, this is for me. Now I'd like to give floor to Mr. Jean Bergavin from the European Commission to deliver his keynote.
Thank you very much, Professor, and Minister, ladies and gentlemen. It's a great pleasure to be here. First of all, I'd like to apologise. Commissioners couldn't come, but that doesn't mean that we don't attach enormous importance to the subject of this two-day conference. And I'd also like to start off this panel by saying it's a pleasure to see that enforcement kicks off the 2 days. Usually enforcement is at the end of such conferences where everybody's already half leaving the room. So I really welcome the innovation by the presidency, and please keep doing that. So let's put it that way. Why do I say that? Because the enforcement issue is a horizontal one. It covers all of the rights that the distinguished guests here cover as well. And the title of this particular workshop, I think, is key in terms of what we're saying, shaping the future. I think that one of the issues here is that IPR enforcement, not only, but in a digital environment. And I think that there are three key positive changes, I'm going to make that very clear, that have arisen with the integration and the use of the internet and digital into the business environment generally. The first one is, as an economist, I'm not a lawyer, is the lowering of transaction costs. It's clearly encouraged enhanced specialization, so focus on competence, and it's resulted in far more complex but also very efficient supply chains. In fact, these days you talk about supply webs, you don't talk about supply chains anymore. And to give you an idea, most suppliers, even in the most complex industries, most producers will not know beyond tier 2 who their suppliers are. That's something to keep in mind when we come back to the issue of enforcement. The second element, which was already raised by the distinguished opening speakers, is obviously faster access to market, faster generally, speed. And that's also through two issues. One is disintermediation. The fact that there are platforms there means that the SMEs can actually get to market far quicker than in the previous exclusively offline world. Likewise, the fact that there are platforms is that you can procure quicker from suppliers who you would never have had the possibility to procure from before. And most of that, and most importantly there, is cross-border. This is a key issue, I think, that needs to come across, and you won't be surprised coming from the European Commission and having worked in the internal market for too many years, apparently, is key to our heart. And the last element which is important is that there are also far lower information costs. It's far easier to work out where the markets are, where the future markets are, and you see that in all sorts of ways. Just to give one example is, many years ago I used to deal with advertising. Today with interactive advertising, online advertising, you're actually measuring, you can actually test where the market is and detect it and develop products and services for those markets. So they're the real positives which have really changed the business environment overall. And if I can say one thing is, I do not think there is a digital economy and an offline economy. They are one and the same thing. Every business you can think of is using digital tools today, otherwise they're not in business. And that goes from the micro firm to the biggest corporation. All these factors are positives for the IPR-intensive sectors that you've heard about, which are key in terms of growth, competitivity, and innovation. And as Antonio Campinos reminded us with the work from the observatory, also key in terms of developing a sustainable economy. However, all three of those changes also increase the possibilities for commercial scale infringers to effectively develop their free-riding businesses, both online and offline, so throughout the whole value chain. The scale of that problem is really well demonstrated, I believe, by the recent EU IPO OECD study, which only looked at physical goods, which only focused actually on container traffic, which is not the bulk of the, if you know the area now, there's far more small consignment issues than there were before, new business models in the IP infringing behavior. But those figures are quite astounding. When you're talking about just for that area, and we're talking about counterfeit, we're talking about an estimated 5% of the total imports into the EU being counterfeit. That is a really big issue, and it's a political issue, and one that increasingly, I think, is making the headlines at political level. The challenge, therefore, I think, for national IPR enforcement frameworks, be they civil enforcement, criminal, administrative, or customs, is to be fit for purpose to deal with this new business environment. They therefore need to do a series of things. First of all the different enforcement players have to be well coordinated, both at national, European, and even international level. Secondly, they have to be amenable. This is why I like having enforcement first. It's wonderful having good laws, but if you can't enforce them, they're not worth the paper they're written on. So this is essential, particularly for SMEs, and it's very appropriate that this conference, obviously under the presidency, is here in Slovakia. Yes, SMEs are very important in Slovakia, but they're important across the whole of Europe, and medium-sized companies are our main job generators. So from an economic and political point of view, again, that is essential. Thirdly, the system has to allow for rapid response. The problem is arising more rapidly. You can make a killing online very rapidly from an IP infringing behavior far more quickly than you could before. The system has to be responsive to that. And lastly, it's got to be sufficiently well-resourced. Now, that's a politically incorrect point because it's not the Commission that's going to pay for enforcement. I just passed that message for the enforcers here. And I think there also digital tools can be used to improve that efficiency. As regards now the key part of my speech, which is what are we, the European Commission, doing to do? I think we certainly seek to encourage better coordination, and we've done that, I think, through the establishment of the European Observatory on IP infringements at the EU IPO, where the scale of the problem can be assessed objectively. And I must say the studies that the EU IPO have developed jointly with the member states have been recognised not only by the Council, but also by the Parliament as being objective, to give some real assessment, valuable assessment of the scale of the problems. Secondly, though, also what is good is that it does bring national enforcement authorities together. And although, as Antonio said very rightly, they don't step into the operations field, it is increasingly interesting, and I think that has been one of the main achievements of the observatory, to actually get that cross-discussion, not just across, for example, customs authorities of different member states, but across the different departments involved with enforcement across the member states. And that is really a big plus. I believe that that role can be further enhanced, and we consider that such development in the evaluation will consider further enhancing that in the evaluation of the observatory, which we are currently running and which we will come out with a communication on next year in 2017. The second element, when you actually come to the enforcement, there isn't a negative number yet, so I'm watching him carefully, is that we have used this term, which is wrongly used sometimes, maybe, and saying that we should focus on follow the money. What does that mean, focus? It doesn't mean exclusive focus, first of all, because otherwise I'll be literally slaughtered by the copyright lawyers. But the focus should be there. And that means a focus on commercial scale infringement. In terms of why do we say that, it's the scale of the problem is such, when you see the sort of, I mentioned the 5% of imports, but when you look at the kind of operations which are being organised, whether it's for counterfeiting, piracy, even trade secret, I know it's not an IPR, by the way, IP, but trade secret, hacking, etc. The money behind that is enormous, and it's really, you have to focus your enforcement preventively as well to try and reduce the incentives to get into those businesses. You'll never kill it. Believe you me, the IP infringers, and particularly the best organized ones, are incredibly innovative, and they are far faster, if I can say, because they don't account for the law, than the usual business. So it shouldn't, this is a complex business, and we ought to wise up to that fact and focus how we can deal with it. On this follow the money, that is, we don't exclusively look at the legal framework, we also look at soft law measures. We've done that through the development, the ongoing development of memoranda of understanding between intermediaries, particularly digital intermediaries, and rights holders. We have one MOU, as you know, between the online sales platforms and the rights holders. We're working on another one with the online advertising community and the rights holders. And we are looking also at payment service providers, shipping lines, and this is important, we're also looking at better techniques in terms of supply chain auditing as well. And I'll come on to that in a second. Another area where we can talk about soft law measures, since Benoit Battistelli was talking, is also improving, seeking to improve transparency in the patent field. That's a key issue, and I think certainly working with the EPO, that can be and is the aim is to improve that. Why is that important? I think it's particularly important when you're talking about coming into the area of the UPC. Not all existing European patents were validated across all the member states. There's always this concern that once the UPC comes into being, all of a sudden, good faith competitors in those member states when they weren't validated will be hit with patents. Clearly we have to deal with that. One of the things is to have transparency which patents are coming, if you like. The other is to also look at, from the SME point of view, how those patents will actually be applied under what terms, etc. So that's more the softer measures, again, with coordination working with the different offices. Then, as regards the issue of civil enforcement, as you all know, and if you don't, you should, we are currently evaluating, and with a view of a potential revision underlined, of the IPR Enforcement Directive. And that evaluation, frankly, offers an ideal opportunity that we can, seek to ensure that the civil enforcement system at EU level is fit for purpose, given the challenges that I raised earlier. One of the elements, and you will have seen, no doubt, we have posted the summary of the responses that many of you, including member states, responded to our public consultation. But there are 4 areas there which we're looking at in more detail. One is the whole issue of proportionality, which is particularly important when we come to the application of access to evidence procedures, but not only. Secondly is the issue of damages, where the text is, of course, minimal harmonization, but again, the differences that are applied in different member states are significant and can have a chilling effect. I mean, one of the key things that was mentioned earlier is the costs for SMEs. You don't get involved with litigation unless you actually hope that you will be compensated for the harm that you have suffered. That's one thing. The other side of that equation, of course, is that as somebody who could be defending, you also have to look at some very sensitive issues such as legal costs. Now there we don't think that should be harmonized, don't worry. But we are looking at issues such as the insurance market, the litigation insurance. Could that not be better developed, which would help, again, for fairer access to the justice system and, again, help SMEs. The third area we're looking at, which I no doubt this distinguished panel will deal with, is the whole issue of the role of intermediaries. But let me make one thing quite clear at this point. What IPRES can do is, if need be, further harmonise procedures. What it cannot do is change international private law regarding applicable law or jurisdiction. Because there is one thing which is coming up stronger and stronger in the, certainly in the responses to IPRED, but also in the whole copyright debate, which is how do you get injunctions recognized across borders? That is a big issue. We're certainly not pushing it to one side, but it is an issue which cannot be exclusively dealt with in IPRED. It's a PIL issue. It will have to, and in Commission speak, we are working with our colleagues in DG Just to look how far that can go. I'm going to make a very politically incorrect statement here, so you can kick me off after on the panel. It is easier when you're dealing with a European title. Think about it. If you haven't got a European title, it's rather difficult, because remember, the judge will have to account for their law, and the specificity of their law won't give you an injunction. But I just passed that for the copyright community. You can then move me on afterwards. Finally, I think that there is a key issue that our IPRED review has shown, both by the responses from the public consultation, and which explains why we're taking longer than some foresaw to come out with our evaluation and eventually our revised text. And that is that we feel that there are other issues that have been raised, I've just mentioned one of them, that should form part of a package of measures that we could come forward with. And I'll just come on this in a further. One of the big issues which comes, which is not for us to say, and we won't legislate in this area, is the whole, and this is a very generic term, and please treat it like that, but the whole issue of specialization in justice. We see differences in the member states. We see reforms. There was one in the UK with IPEC. There was another one in Portugal. This is an issue which many rights holders and practitioners come forward with in terms of the predictability of the system. Very sensitive issue, very key. Of course, it's for the member states to look at this, but I think it's interesting to bring that debate out and to respond to the strong request to look at this issue, which has come through in the public consultation. The second issue, which I think we can use the EU IPO more with, I think they're already doing that, is to improve cross-border networking, if we can put it that way, in terms of I don't like the idea of training, but more sharing best practices between the judiciary. And there I think that maybe there can be some thought how to do that through the EU IPO. The third element is SMEs. How do we get them to use? A lot of I think most of the people in this audience know the challenges. You know, IP is a complex area. Justice is never, and good justice costs money. Let's be absolutely clear. The key issue there for SMEs is two things. One, is it, and there seems to be that, the fact that it is costly to apply the law is that they don't use it, or that they are concerned that if they do use it, they won't have the means to defend themselves against, you know, a larger, let's put it honestly, a larger competitor who might abuse the possibility of litigation vis-a-vis a small rights holder. Now that's a massive challenge, but it's one that we cannot just brush under the carpet. You don't throw money at this. You really need to address the issue across the board. And I think there we are hoping to come out by the end of this year with a communication on what they call startups and scale-ups, which will make a direct link to the need to look at measures that we could encourage to help SMEs. And that spans a lot of things. That can, as you know, with the development in the UPC, there was very much the idea of a specialized mediation and arbitration center. Mediation and arbitration with a trusted third party, we would hope would give better results, or let's say fairer results, more proportionate results than when you simply have bilateral agreements, out-of-court agreements. That is something where digital technology can help as well. Do you necessarily, in those centers, can you not use the new digital technology to make such arbitration and mediation really very accessible from wherever you are in Europe? They're issues that I think we need to look at. But as I say, we will be coming out with this communication before the end of the year, and it will have a detailed, not annex, but paper associated with it, looking at the whole SME IPR issue and making suggestions there, how we could work with the member states more as well. And last point, I think that what I would end with here is, and this is maybe I'm overstepping my mark, the UPC is on the road. I know that there are big questions at the moment. All I can say is, I'll say something which is politically incorrect again, and then you could get, is, you know, intergovernmental agreements take time. Sometimes a bit too much time. That's me as a European official speaking. So here we are now. However, it's very much in the member states' hands, all of you. And I do think, you know, this is a golden opportunity that should not be missed. Setting up such a system, building on what Mr. Battistelli said, which is a very good quality performing registration, patent registration system in Europe, and having a unified court would be a massive step and a very positive message for how we are dealing with the whole issue of this new business environment, and particularly with patents. With patents, I think the most revealing figure is that we estimate that 30% of, and you can always talk the statistics about, but we come out with this figure. In our innovation scoreboards, we estimate that 30% of our SMEs in Europe are innovative. Okay? Now that doesn't mean they should all have a patent, but when you see that only 0.3% of them do, that is very clearly an issue. And it is, please remember, it is our medium-sized companies, I'm particularly focusing on them, who are our growth generators. And we can all be very positive on this beautiful day here in Bratislava, but Europe is not exactly in an economic high point at the moment. So the UPC is really something that I would urge you, and this is more of a personal point, to push for. And don't wait another 14 years, which is the typical cycle we've been hanging on to for the past 40 years, to make that step and get there. Thank you very much.
Thank you very much for this wonderful keynote with a lot of food for thought. And now I'd like to invite our second speaker on the panel, Mr. Justice Arnold.
Well, it's a great honour and pleasure to be addressing this distinguished conference this morning and to be here in Bratislava. Now, I'm going to be talking on the subject of current UK practice and the need for further harmonisation. And it's important at the outset to make clear that I speak in two contexts. The first context, Jean Bergerin has already told you about, namely that the Commission is undertaking its 10-year review of the IP Enforcement Directive. And some of what I have to say is specifically directed to that question. The second context, for the avoidance of doubt, is that, of course, now and for at least 2 years to come, the United Kingdom is a full member of the European Union. Now, having given you that context, let me give you the overview of what I'm going to be speaking about this morning. I'm going to talk on three subjects. The first is the current position in England and Wales with respect to website blocking injunctions following the decision of the Court of Appeal in the Cartier and Sky case, which was handed down on the 6th of July this year. Secondly, I'm going to move on from that to talk a little bit about the diversity of practices and outcomes around Europe with regard to website blocking injunctions. And that will then take me to my third topic, which is the need for a more harmonised legal framework, both specifically in relation to enforcement against intermediaries and more generally. So, let me talk to you about the current position in England and Wales following the Cartier and Sky case. And the headline is simple, namely that the Court of Appeal has entirely confirmed the jurisprudence that was built up at first instance in England and Wales since 2011. and those of you who will be familiar with this subject will have read many rather long judgments of mine on that subject, and the Court of Appeal has entirely agreed, I'm happy to say. It is also important to appreciate, of course, that this is not necessarily the last word on the subject in England and Wales. Currently, the ISPs in the case are petitioning the Supreme Court for permission to appeal, and therefore there may be more to be heard on this subject later. The Court of Appeal has confirmed that the courts of England and Wales have jurisdiction to grant website blocking injunctions to combat trademark infringement and, by implication, any other IP right, despite the absence of any specific implementation by the United Kingdom of the third sentence of Article 11 of the Enforcement Directive. And that is in contrast to what the United Kingdom did with Article 8.3 of the Information Society Directive in the field of copyright, where that was specifically implemented in our legislation. Why the United Kingdom, having specifically implemented Article 8.3 of the InfoSoc Directive, chose not specifically to implement the third sentence of Article 11 of the Enforcement Directive is a bit of a mystery, but what the court has said is it doesn't matter, the court has the necessary jurisdiction. That then led on to the next point, which is that the court was satisfied that the jurisdiction was one that was adequately prescribed by law. You will all be familiar that that is a requirement both under the European Convention of Human Rights and under the EU Charter of Fundamental Freedoms. Next, the court confirmed that in this context there are 4 threshold conditions for the grant of such an injunction. Firstly, that the defendants are intermediaries within the meaning of Article 11 of the Directive. Secondly, that the users and or operators of the website are infringing the claimant's rights. Thirdly, that those users and or operators are using the defendant's services to infringe. And lastly, that the defendants have actual knowledge of that, which may be as a result of being notified by the right owners. So those are the 4 threshold conditions that have to be established in order for the court to have jurisdiction to grant such an injunction. Moving then on to the principles to be applied when deciding whether or not to grant an injunction, assuming that the court has the necessary jurisdiction, the Court of Appeal has confirmed that in order for an injunction to be granted, it must be 1, necessary, 2, effective, 3, dissuasive, 4, not unduly costly or complicated, 5, avoid barriers to legitimate trade, 6, be fair and ethical and strike a fair balance between the fundamental rights engaged, 7thly, be proportionate, and 8thly, be safeguarded against abuse. Now, if you look at the reasoning of the Court of Appeal, it becomes clear that the Court of Appeal agreed with me that of these factors, proportionality is the key consideration, because consideration of all the other factors ultimately feeds into the proportionality analysis. So proportionality is absolutely front and centre of consideration of these remedies. Now, when we come to consider the proportionality of the injunction, the courts of England and Wales have all been agreed that an important consideration is the nature of the technical measures which the ISPs are required to adopt, and hence their efficacy, costs and impact on lawful users. And for those of you who aren't aware of this, it's an important aspect of the background to the development of this jurisprudence in the United Kingdom, that throughout the process that has been going on since 2011, what the right holders have been asking the ISPs to do is to use technical measures which the ISPs already have. There has been no request by the rights holders in any of these cases for the ISPs to develop new technical measures. The request has been, you have the technical measures, please use them for this purpose. Now, the next point that the Court of Appeal has agreed with is that although it is true to say that website blocking injunctions are quite easily circumvented, it does not follow that they are ineffective. The evidence shows that they are effective in reducing traffic to targeted websites. Of course, they do not eliminate traffic to targeted websites. It is a question of reduction. And then the question then is whether the extent of the reduction warrants the cost of implementing the injunction. And that is a question of proportionality. It is a cost-benefit analysis. The theory which underlies this jurisdiction when you look at the directive is that of lowest cost avoidance, to use the economist's jargon. That is the policy, and if that is the policy, then it becomes a question of analysing as a matter of cost and benefit whether the remedy is proportionate. Now, to date, the approach that the courts of England and Wales has adopted, and the Court of Appeal has again confirmed this, is that the costs of the application for the injunction shall be paid by the right owner, while the costs of implementation are to be paid by the ISPs. But the door has been left open to different orders, and it is worth mentioning that that is the only point on which so far there has been any sign of judicial disagreement. One member of the Court of Appeal dissented purely on the question of costs of implementation. The majority were content with the position as I have stated it. One member thought that the rights owners should also bear the costs of implementation, and that may be an issue that the Supreme Court will want to look at. Now, another important practical point to appreciate is that the orders that have been made in England and Wales enable the right owners to notify the ISPs over time of any other IP address or URL whose sole or predominant purpose is to provide or facilitate access to the target website, and that must then be blocked. And that's very important from a practical point of view, because of course as soon as a website is blocked, what will happen is the website operator will change the URL, change the IP address. So you've got to be able to react to that, and that's what the orders enable to happen. Another important point is that the orders incorporate various procedural safeguards, and these have been developed over time. And the current position is that those safeguards include ability for the ISPs to apply to set aside or vary the order in the event of change of circumstances. Users and operators can also apply to do that. Information about the block must be displayed at the relevant place on the web. And there is a sunset clause. So the current form of order provides for review after 2 years. And there is, importantly, no requirement to sue or attempt to sue the website operators first. Now, if we then move on to my second topic, which is the diversity of practices and outcomes around Europe. If we survey the landscape in 2016, we see that there is a considerable diversity of practices and outcomes. So, for example, courts in some countries, such as currently Germany, require right owners to try to sue the website operator first. It's not an absolute requirement that you shall do so, but you must at least make the effort. Whereas other countries, like my own, we don't require that. Secondly, courts in some countries, such as my country, we specify the technical measures to be adopted by the ISPs, while courts in other countries, an example is Austria, leave it up to the ISPs to decide what technical measures to employ. Courts in different countries take different views on efficacy of such injunctions, hence proportionality. So, for example, in the Netherlands, quite a sceptical attitude has been taken to the efficacy of these orders, whereas, as I say, in my country, we're convinced that they are effective in reducing traffic. And the acid test is the outcomes. Even in parallel cases around Europe, you see divergent outcomes. And the most notorious example is the Pirate Bay. So courts in some countries around Europe have blocked the Pirate Bay. So it's blocked in the UK, it's blocked in Italy, it's blocked in a number of other countries. But some countries, it's not blocked. It's not blocked currently in the Netherlands, it's not blocked currently, I believe, in Germany. So we have a diversity of outcomes. Now, that then leads on to my to consideration of, well, why is that? Why do we have these differences? Now, I would accept that some of these differences are inevitable due to different national legal systems and procedural laws, but others are not. And I would identify three key reasons for these differences. Firstly, differing national implementations and interpretations of Article 8.3 of the Information Society Directive and Article 11 of the Enforcement Directive. Now, there has been some degree of bringing together as a result of decisions of the Court of Justice of the European Union in cases like Scarlet Extended and Sabam and UPC, but so far that process has only extended so far. There are still considerable differences. A second reason is problems with the underlying substantive law. And this is particularly true in the field of copyright, where, as everybody knows, there are the problems that are ongoing with the concept of communication to the public, and in particular the circumstances in which hyperlinking can be an infringement. And we've had a series of CJEU decisions, culminating most recently in the GS Media case, but the story is not over. There are still cases pending before the Court of Justice on this topic. But the third one, which I particularly want to highlight to you this morning, is the absence of harmonization of accessory liability. And this is, in my view, a very important and overlooked aspect of this problem. It's not just a question of procedure, it's not just a question of substantive law. This question of accessory liability is absolutely critical, because when you look at the different court decisions around Europe, you see this problem comes up time and time again. So if you compare decisions in England and Wales with decisions in the Netherlands, for example, one of the reasons for the different outcomes, it's not the only reason, but one factor is different laws on accessory liability. So, where then does that take us in terms of the way forward? Well, if there is to be greater consistency, and I assume that greater consistency is desirable, others may differ on that, but if we agree that greater consistency is desirable, then a more harmonized legal framework is required. And I would offer 3 steps to meet the 3 reasons that I've just identified. A first step would be a more harmonized legislative basis for injunctions against intermediaries whose services are used to infringe IPRs. And I offer merely some suggestions about that. There are other suggestions, I'm sure, which could be put forward. One could specify more clearly who is an intermediary, because there are open questions on that subject. Is a payment services provider an intermediary? Is an advertising services provider an intermediary? These are still open questions. So one could specify more clearly who is an intermediary. One could specify more clearly the threshold conditions to be satisfied. One could specify more clearly the essential procedural requirements. E.g., is it required to bring a claim against the infringer, or is it not required? A second step would be a more harmonized basis for the underlying claims for infringement. And given that most of the claims to date concern copyright infringement, that would mainly relate to the copyright acquis and in particular communication to the public. But I would emphasize to you my third suggestion, which would be harmonization on the rules on accessory liability for intellectual property right infringement. Currently, there is no harmonization on this subject whatsoever. And just to ram this point home, can I say this to you? One of the subjects we're talking about at this conference is the Unified Patent Court. When the Unified Patent Court agreement was negotiated, one of the points I made repeatedly was that there was no provision in the draft agreement dealing with accessory liability. My request was ignored. So the agreement as concluded says not one word on accessory liability. How can you have a unified patent court system around Europe with no harmonization of accessory liability? You can't. It is a hole. Now, the point is, what are the consequences of that hole? The answer is the hole will be filled by the court if and when it comes into existence. But think of the costs of that. Who pays the costs of the hole being filled by the court? Answer, businesses around Europe. The businesses who litigate in the court will pay the costs, but also all the business who have to take legal advice until such time as there is a clear decision from the court. So a failure to legislate imposes costs on business. All right? So that is my message to policymakers in the room. Thank you very much.
Thank you very much. I think this was full of ideas, even roadmap for the European legislator. Critique, I think this is all we want. And in the spirit, I'd like to continue and invite our third speaker, Ms. Zuzana Hečko, to deliver her presentation.
Thank you, Martin. What a privilege to have a speaking slot after the most famous IP judge in Europe, isn't it? Right, I'm going to speak about some local aspects of enforcement. So we have heard some UK experiences with block and injunctions. We have heard from Jean what the Commission is doing, and I'm going to tell you what it looks like in Slovakia. So before I come to the details, perhaps just a short and brief information as to what sort of IP cases we see in Slovakia. And to some of you, it's not going to come as a surprise that Slovakia is no patent cases jurisdiction, so those of you who would be waiting for those big patent cases like we see in Germany or UK would be waiting for a long time. So it's more or less soft IP jurisdiction. We see a lot of trademark infringement cases. That usually goes hand in hand with unfair competition, so whatever is considered as trademark infringement often fulfills also unfair competition disputes. Yes, we also see counterfeiting cases. We see as well copyright infringements, although perhaps the case law hasn't yet reached those famous website blocking injunctions, perhaps in the short future, who knows. We see domain name disputes and some limited IP litigation. So that would be very briefly what this jurisdiction brings in terms of intellectual property disputes. So how difficult or how easy it is in Slovakia to defend intellectual property? Perhaps a note to mention is that from the 1st of July we have a new civil procedure code which actually to us, trademark professionals and practitioners, makes life a lot easier. Why is that? From many changes that it brought, I dare to mention 4 of them. So you can see 2 of them are green, 2 of them are red. You'll probably guess easily that those in green bring some positive changes. Those in red are still somehow complicated. So let's look at the first one. As of 1st of July, thank God we have a new specialized court, and it's not only specialized court, but we can say it's truly specialized court. So all IP cases are being heard by the court in Banská Bystrica. Most of you probably have never visited that town. It's a rather small town in the middle of Slovakia. Why that town? Because our intellectual property office is located there. And since that court often heard a lot of disputes that had to do something with trademarks or with other industrial property rights, that court is going to now hear intellectual property or industrial property rights cases. What perhaps is not such a good news that court, unfortunately, I don't know why, will not hear copyright cases, so it's really gonna hear industrial property rights, but it's still very good news because most of us so far had to go to the Bratislava court to handle our disputes. Not saying that that court is not good, but it takes time to get a decision in that court. Whereas the court in Banská Bystrica is definitely a lot faster. And it knows its stuff, I must say, because, as I said, it is the court that is in the same town as the industrial property office. So that's the first positive change that the new civil procedure code brought. Second one, which actually didn't change much because it was there before, but I still would like to mention it to you because often practitioners or general public say, oh, it's so difficult or close to impossible to enforce rights in Eastern Europe. I don't think that's true. We have a very effective system of preliminary injunctions. So these are preliminary protection measures, and in Slovakia they're granted within 30 days. And when I say 30 days, I mean 30 days. So I mean like you file your claim, and within 30 days you will either hear good news, or sometimes, not that often actually, thank God, you get a decision. In Slovakia, these measures are granted ex parte. What does it mean? One day you come to the office, make your coffee, and then the decision is delivered to you and you have to comply immediately. So that's great. And part of the preliminary injunctions, often in Slovakia, at least as practitioners, what we have seen, is also recall of the goods from the market, which is not so frequent perhaps in some other jurisdictions. So preliminary protection, I dare to say, works quite well in Slovakia for industrial property or intellectual property rights. Now, of course, not all of the measures can work as practitioners may wish. So there are also some things that could be improved. Other provisional measures are very famous word, saisie contrefaçon, as some of you may know it. Yes, it does exist in the law, we do have it. However, the procedure is not described as to how we can actually get saisie contrefaçon. So while this right is allowed and it is part of the new code, it doesn't say when the decision is delivered or whether a person like court bailiff or a customs officer or police officer can actually come and serve the decision. So this is something that as practitioners we have this possibility to use this right. However, no one, and I don't know any other practitioner that has ever tried actually to use it. I myself had a case where something like this would have been very, very useful, and it would have been the only way in how to solve the problem. But at the end, we just decided with the client that we would not use it because it was simply too risky. And damages, this is not going to come as a surprise. Yes, very low, doesn't compensate at all for the damage that has been caused by the infringement. However, I think people don't sue to get damages. People file lawsuits to actually correct the situation. And so often when they see a very strong preliminary injunction granted, ex parte, within 30 days, perhaps with the recall of the goods from the market, then the clients are usually very happy even if they get very low damages. So let's say that we had a problem, we solved the problem, we have some nice preliminary injunction granted, and then we simply see that our counterparty does nothing. In other words, they totally ignore the decision that has been rendered by the court. Frustrating moment for the client as well as for the practitioner, and so we actually proceed to the next stage, which is forced enforcement. Now, while if there is some financial obligations to be enforced, that usually is easier. The problem could be if there is no financial obligation, is the subject of the forced enforcement. In that case, what can be done is that forced enforcement may be followed by fines. These can be imposed even on multiple times. In Slovakia, if you have a small company or medium-sized company, and if forced enforcer imposes a fine of 5,000 euros, many people say that is peanuts, and that may be peanuts, but in Slovakia, it's not that small of amount of money. So sometimes it works, and they can impose it even multiple times. However, for big infringements, when there are products which generate a lot of profit, with the maximum possible fine that can be imposed, which is currently 30,000 euros, often infringers simply calculate, and it's not difficult maths to do, and they simply choose to ignore all the measures that have been granted by the court, because 30,000 at the end of the day, if it's some blockbuster drug, for example, it's really nothing. So that remains a problem. Right, and I was told by Martin, since many people on this panel will touch upon different aspects of IP, and apparently no one will actually speak about customs enforcement, so he asked me to say a few words about customs enforcement, because I don't think there is a practitioner on this earth who has never done a customs case. Now, we could speak about many aspects of customs enforcement, but what is particularly trendy these days, and I myself actually, so even in small jurisdictions, people have experienced and difficulties with the issue of transit. I'm not going to go into the details how difficult it is to actually seize the goods in transit. Many of you will have had experience. In any case, before those changes that I've listed in my presentation, it was really difficult to do anything with those goods that are fake, but are put into the customs regime transit, because those goods, basically, they are physically on the territory of the European Union. However, legally speaking, they are not fake. So, and we practitioners, we actually had to prove that those goods would be put on the market in the European Union. So imagine that you have a couple of thousands or even millions, which was in my case, of truly fake goods. They are sitting at some port and they are waiting to be transported to, for example, Senegal, and you know that they are just simply not going to go there because no one in Senegal would ever know that brand, and you know that they are going to end up in the EU. However, you have to prove that they are going to be put on the market in the EU, whereas all the documents basically just suggest that they are going to go to Senegal. Because don't forget that while rights holders have excellent attorneys, counterfeiters have excellent attorneys as well. And so for that reason, it has been a long discussion as to what would be good to do, or what can we do with those goods that are put in external transit. So regulation, Customs Regulation 2013, that was the new regulation to which many practitioners were putting a lot of hopes that would actually solve the problem of goods being put in transit. Then again, when the regulation came out, there was a big disappointment that basically close to nothing was done to resolve the issue of transit. And so other legislative instruments had to be adopted to actually solve this problem. So the good news actually came with legislation on trademarks, and it's the regulation 2015-2424, which is amendment of the EU trademark regulation, and then a directive again from the same year, which is for the national trademarks. And I'm not going to repeat all the quotations, you can find them on the slides, but basically that piece of legislation tells us that even those goods that are not put into free circulation, so those goods that are in transit, can be considered as trademark infringements. In other words, we practitioners may actually have a chance and possibility to seize these goods even if they are in transit. That actually is going to apply only to some trademark infringements, so that's identical or identical in its essential aspects. One thing that I found quite surprising, but I guess that's the result of the political discussions when I read the new pieces of legislation, especially the Commission decision on this customs new regime, was to do with fake medicines. And there it says, customs authorities should not detain medicines in the absence of indications that they are intended for the EU market. When I read this decision, I say, or my interpretation as a lawyer would be, don't touch the medicines. Well, it remains to be seen. In any case, we have new law. Let's see how we can use it. As far as the regulation is concerned, that is applicable only already from March 2016. So let's see how successful this measure is. As far as trademark directives, so that is for the national trademarks, which often will be the case actually for us practitioners to use. We have to still wait a little bit. 2019 is the date when the member states actually have to transpose. So still a few years to come, so hopefully the regime is not going to change, that this piece of legislation by the time it enters into force will be useless. In any way, this is good sign and good hope for those goods that are in transit, so they are sitting in our ports, yet they are aimed artificially for third countries where they are never going to go. And this brings me to an end to my presentation. If you have any questions, I'll be happy to take them. Thank you.
Thank you very much. I think you allowed many guests, especially international guests, to have a glimpse of enforcement of IP rights in Slovakia. Now, I'd like to give the floor to our last speaker, Professor John Golden.
Okay, well, thank you for having me here on this panel. It's a great pleasure to be at this conference and to be in Bratislava in particular, and Slovakia more generally for the first time. Martin mentioned how I've been spending much of this fall in the Netherlands escaping the US elections. That's not quite true, certainly as my motivation. I was back, I actually flew here from Texas, where I voted last week, doing early voting. We're hoping a number of people voted early. But I must say, it is a breath of fresh air to be at a conference where what is considered a politically incorrect statement is the statement that intergovernmental agreements take time. So, in any event, I'm going to talk here today about something that's not directly about what's happening in Europe, but I think touches on issues that and concerns that you need to consider as well, and that you need to consider perhaps particularly if you're focusing on trying to strengthen intellectual property rights, because what we found with regard to patent remedies in the United States is that maybe we need to think about how, in some ways, to restrain or limit the rights that we've originally granted. Okay, all right, so U.S. patent remedies, like remedies and enforcement generally, and this goes to our kind of keynote speakers' comments, like remedies generally hadn't been very much discussed a little over 10 years ago, but they've become one of the hottest and most controversial areas in U.S. patent law and really in intellectual property law generally in the United States within the last decade. And this is largely a response to concerns that patent rights might have become too powerful or too strong, and that they could, in certain circumstances, excessively interfere with innovation by raising the cost of doing business so that they're too high. This has been a particular concern with regard to two developments. One, the proliferation of multi-component, complicated products and innovative processes like smartphones, which can incorporate thousands, even arguably tens of or hundreds of thousands of individual innovations. And then the question becomes, what sort of remedy, what kind of injunction, or what kind of monetary relief, money damages, should you give to a patent owner who owns a patent on only one component or one aspect of the smartphone? We have a case currently before the Supreme Court where part of the question is, how much should Apple get from Samsung for the rounded corners of the smartphones and tablets? A jury in the United States seemed to think that was worth hundreds of millions of dollars. More recently, even beyond the multi-component problem, we've had concern about entities which are often called patent trolls. These are companies that specialize in acquiring patent rights and enforcing them against others, either through licensing or the threatening of a bringing of a lawsuit or the actual bringing of suit. And part of the concern here is that these patent trolls could be enforcing relatively weak patents, bringing suits that should not succeed in court, but they can effectively force many entities, including many small or medium-sized businesses, to pay settlement costs, to pay for a license to the patents, simply because those businesses want to avoid the cost of litigation, which in the United States, as the last line indicates here, could be in the nature of millions of US dollars, which would also correspond to millions of euros. Okay, so what's happened as a result of this is we've seen that injunctions and the availability of an injunction for a successful patent holder in litigation has become questionable after a Supreme Court decision in 2006 in a case involving eBay. The main result of this Supreme Court decision is that injunctions have become very difficult to obtain by patent trolls and other patent holders that do not actively practice the invention, in particular ones that don't compete with the patent holder. So if you have a patent on an aspect of a smartphone, but you don't manufacture smartphones, if you're not competing with a smartphone maker, you're very unlikely to get an injunction against Apple or Samsung or the other competitors in the smartphone space. Another area where we've seen the courts pushing to restrain patent enforcement substantially has been with regard to money damages. The median damages award in the United States for patent infringement in the past approximately 5 years was $7.3 million, or approximately 6.6 million euros. And beyond that, we've seen some damages awards which are much, much larger. Since in the last 10 years, we've had 5 damages awards from juries of $1 billion or more. Most of those awards have been later reduced substantially by the courts or even by a later jury after a new trial, but they do raise the risk for businesses, which you can imagine worry about potentially being hit with a $1 billion damage award because their smartphone has rounded corners or has some other patent infringing relatively small aspect. Okay. So that's the basic introduction. I'm going to just give a little overview of where this is coming from in the United States. We have a number of venues where patent litigation can be pursued in the United States. The main one, and the main one of concern for these injunctions and money damages, are the United States district courts, which are spread throughout the country and where you have judges who generally do not specialize in patent law. In addition to having judges who don't specialize in patent law handling these cases, ultimately the crucial fact finder in many of these cases I've already referenced are juries. So in the United States, there's viewed as being a constitutional right to a jury of just individual citizens who, generally speaking, aren't going to have a background in law, generally speaking, aren't going to have a background in the particular technologies at issue. These juries are going to decide whether a particular patent is infringed and often, if they do find infringement, the amount of any award of damages. And that's where we've seen a number of these billion-dollar damages awards come from. We do have, just to mention something about customs, we do have a specialized administrative court, the International Trade Commission, which is available to obtain what's called an exclusion order to prevent certain devices or components of devices from being imported into the United States. But that administrative court can't provide money damages. It can only provide this kind of limited form of injunctive relief. There are also other forms for challenging patent validity or proceedings for challenging patent validity currently before the USPTO, which have become more popular and prominent in the last few years. Okay, what types of remedies are available in patent cases? And here I'm focused on what we call utility patents, which are patents in the nature of what you probably consider to be patents in Europe, patents that are directed at functional aspects of products or processes. Well, we have the injunction, and there you can get a temporary restraining order, a preliminary injunction, which is not going to be ex parte in the United States and is quite difficult to get, and then a permanent injunction, which is the type of injunction you can get if you win the full case on the merits after a full trial. As I said, we have seen a sort of limitation, a restriction of the availability of injunctions after eBay. If you don't get an injunction, you can get what's called an ongoing royalty, where the court can say to the infringer that, well, we think it will impose, say, excessive hardship on you to remove a patented component now that you've already built your device. But we do recognize you're infringing, so instead you're going to have to pay a court-set royalty for the future use of the patented technology. On the other side of things, looking backward, we have damages available for past infringement. And there we have compensatory damages, which could be lost profits if you are a competitor and you lost sales to the infringing party. Or if you can't prove lost profits, you can obtain what is called a reasonable royalty. And this has been really the main focus of argument as the debate has been, say, what percentage of the value, say, Samsung's profit should Apple be able to get for the ability to change the page on a smartphone or a tablet by swiping your finger across the screen? A very difficult question. And that's why we refer this difficult question to a panel of several people who know nothing about patent law or the relevant technology. Beyond compensatory damages, we have a possibility of enhanced damages, generally speaking only for people who have been egregious infringers in some sense, historically a sense that you need to be in some way a willful infringer. That goes up to 3 times the compensatory damages award. And then finally, court costs and interest, which go to some of the sort of filing fees you have before the court and interest for sort of damages that occurred in the past but are only being paid for now. On attorney fees, you should note, if you don't already know, that in the United States, the usual rule is that the losing side does not pay the winning side's attorney fees. The U.S. Patent Act does make a provision for awarding attorney fees in exceptional circumstances. The United States Supreme Court has loosened that standard a bit, but still the general rule is that you don't get your attorney fees paid by the other side even if you win the case. And that's unlike many other systems. Now, you might note, if you're an expert in patent law, that there's one remedy missing on this list that is commonly seen in other jurisdictions, and that's the ability to disgorge the infringer's profits. So to say, well, the infringer made $6 million as a result of the infringement, I can get that back from them. That was eliminated in the United States utility patent law some time ago. It is still available for what we call design patents, which an example of a design patent would be the rounded corners of the smartphone. Apple has a design patent on that. Apple also has a design patent on sort of the icons or the arrangement of icons on the screen of a smartphone. Okay. The United States Supreme Court right now is considering the extent to which when you disgorge an infringer's profits, you really get to get all of their profits, or perhaps only the profits associated in some way more particularly with that design element. Okay. All right, I've mentioned the United States Supreme Court a number of times. We have had a series of cases in which they have intervened in patent law. The eBay case on the standard for permanent injunctions. We had Octane Fitness and Highmark in 2014, where, as I mentioned, they made attorney fee shifting a little more available in the United States. And attorney fee shifting is not a minor aspect of the enforcement regime. Some people believe that the reason that Europe has not developed a so-called patent troll problem is because of the general European rule of shifting attorney fees, allowing the winning side to get at least part of its attorney's fees paid for by the losing side. On the other hand, there's a great concern that having the European rule for attorney fee shifting makes intellectual property rights a little too difficult to enforce, particularly for small or medium-sized entities that, if they're suing a large company, don't want to risk having to pay, in the United States, millions of dollars for the other side's attorney fees. So it's a very difficult and interesting policy issue as to what the right rule is there. Enhanced damages, the Supreme Court just this year has made a little more available, so that's somewhat unusual for our U.S. Supreme Court to have a more pro-patentee, a pro-patent holder decision in that respect. And as I mentioned, the court currently right now is considering the availability of design profit damages. Okay, I'm running out of time, so I'm going to shortly get the -1, I think, because I think on my stopwatch I just hit 15 minutes. So I shouldn't tell Martin this, though. Maybe he wasn't paying attention. But I'll cut to one other issue, just a little more detail on eBay. As I mentioned, in eBay, the Supreme Court made permanent injunctions a bit more difficult to get. And they've been particularly difficult for non-practicing entities to get, entities that don't compete with the infringer. The factors that a patent holder has to satisfy in order to get a permanent injunction are listed here. Irreparable injury, inadequacy of legal remedies, and these might be viewed as connecting to the necessity factor that Mr. Justice Arnold mentioned a little earlier. The balance of hardships and public interest factors might be viewed as connecting to a number of the other factors that he mentioned. Not unduly costly or complicated, fair and equitable, proportional, safeguarded against abuse. So at least from the U.S. perspective, these sorts of factors that were suggested earlier might be something that Europe should consider more generally with regard to potentially limiting the availability of injunctive relief for patent infringement. And with that, I'll close and turn it back to Martin. Thanks for your time and attention.
Thank you very much, John. I think it's very interesting to see what is happening in the United States also for us in Europe. We finished a little bit early, so we have a little bit more time for discussion, so that's the reason why I wasn't stopping you, but if you'd like to stay to 15. But now we have more time for discussion. So I think the best approach would be first to open floor for discussion. So if you have some burning questions, we can come up with them. And if not, I have many, many questions that I would love to ask our panelists. Yes, please.
Thanks very much, Matthias Leistner from Munich University. Thank you to all of you for giving this excellent overview. And I'm afraid against the background of that overview, I have a rather specific question to Mr. Justice Arnold. You highlighted some of the differences we have observed throughout Europe with regard to blocking injunctions concerning ISPs. And one of these differences was that whereas you in the UK, rather specifically all the measures to be taken, we in Austria and Germany tended to hand down what was called open injunctions, basically leaving the ISP the choice of the proportionate and appropriate blocking measure. That was confirmed by the ECJ, at least in my understanding, in the UPC Telekabel case. But however, it was a little bit contended in the recent McFadden case, which was handed down in parallel timely to GS Media. Preliminary to the case, Advocate General Spooner considered to say, well, at least the court will have to check of whether there is a possible measure at all which would be proportionate and workable on the side of the provider. And whereas the ECJ hasn't really confirmed that approach, still the ECJ has chosen some specific measures a wireless LAN operator will have to take. Now, setting aside the question of whether these measures are really proportionate and practical, still, do you think, Mr. Justice Arnold, that this is a little step into the direction of the English approach, the ECJ perhaps in the future requiring us to further define what the defendant will have to do in these blocking cases?
Well, the question is inviting me to speculate as to what will be the future decision of the Court of Justice when presenting with this question. As we all know, trying to predict outcomes of cases in the Court of Justice of the EU is not always very easy. That said, what I would say is this. My experience has been that if you have an order which specifies in fairly precise terms the technical measures which must be adopted by the defendant, certainly in these ISP cases, it does have the advantage that it enables the court fully to assess the proportionality of taking those measures. Because if the measures are fully specified, then the court has all the information. And let me illustrate that by repeating a point I made earlier. In the UK context, the orders that have been made have been ones that required the ISPs to use existing technical measures that they already had and were using for other purposes. In particular, in the very first case, it was to use the measures that they were already using to combat child pornography. So they had the technical measures available, and the question was, please could you use these measures that you already have for this new purpose? Now, as you will appreciate, there's a big difference between taking that approach and making an order whose effect may or may not be to require the ISP to adopt new technical measures. And the most obvious difference is one of cost, which feeds into the cost-benefit analysis and therefore the proportionality analysis. Because if the ISPs are instructed to use existing technical measures, then the cost of that will be low. I'm not saying there's no cost. On the contrary, they may be required ultimately to scale up their infrastructure, and certainly there's an ongoing implementation cost, and it's not negligible, but it is relatively low. Whereas if you have an order that requires new technical measures to be adopted, then the cost is likely to be much higher. Now, the argument against what you described as the open-ended order is that those orders tend to be expressed in terms of the result to be obtained. And that can be problematic if it is interpreted in a way that makes the result to be obtained viewed in an absolute way. Because then you get into an argument of, well, how far does the defendant have to go? How far must they attempt to achieve this result? Now, I think what the Court of Justice has done so far is to adopt a pragmatic attitude and to say, well, we recognise that national legal systems vary, procedural laws vary, and until it's shown that adopting an open-ended order causes real problems, then we will accept that. But I think the clear message from what was said in both UPC and McFadden is that the Court of Justice is not ruling out the possibility of being more prescriptive if experience shows that open-ended orders do impose excessive costs and do impose barriers to legitimate commercial trade.
That is very interesting. Do we have some additional questions from the floor? Yes, please.
Press the button? No, it works. I'm Michael Walter from Vienna University. I wouldn't like to ask a question, but I would like to make two short, very brief remarks on what was said during this August panel. First remark relates to what Mr. Judge Arnold explained to us and the message he sent to the Commission. Please deal with the question of secondary liability or accessory liability, and I would like to very much underline the necessity of doing so. I think it's at least as far as copyright infringement is concerned, I think it's rather important to know who is infringing. And in this context especially, I think the world has been turned upside down by the e-commerce directive for the safe harbor provisions in Articles 12 through 14 of this directive. So it's not the person or institution who indeed communicates copyright work or other subject matter protections, but it's the liabilities turned on the shoulders of the single private, maybe user, who's doing nothing else than uploading. So I would stress the necessity of thinking over this problem. Second brief remark, please don't forget the right to information, which indeed is enshrined in Article 8, as everybody knows, of the Enforcement Directive, but it does not at all work in all member states of the EU. So it's a very important point, for if you don't have the information, there is no possibility to sue for copyright or other infringement. Thank you.
Thank you very much. I think this question is for both Mr. Justice Arnold, but also Mr. Bergavin in a sense. So.
I'm very honoured by that. Thank you. I'll go first and put my foot in it, maybe. First of all, on the call, and I've heard it, and to be quite clear, responses from judges from the UK to the consultation, this call was made very clearly for the need for harmonisation of accessory liability. I certainly wouldn't say no to it, speaking as a European, not at all. But it's a general point that Justice Arnold said. It's, you know, as he rightly said, maybe you shouldn't leave everything to the court. The problem in this field, and we are looking at this, I mean, I don't want to discard this. When I was saying that with IPRED, with the revision, we've put it back, as you probably heard. We had originally foreseen, the Commission had foreseen to come out with its results at the end of this year. That is slipping now. And one of the reasons for this is precisely for these kinds of issues that were raised, which are key issues. The question has to be asked whether it has to be done in IPRED or even in a separate measure. That's from a Commission perspective. But it is an issue that also, to be fair, one major member state, I won't mention it, it's not the UK, has also raised in its response that we should look at the issue of accessory liability in a general context with a principle, and I don't want to mix things up here, but more a principle of due diligence. Or if you like, an obligation of means rather than result, as Justice Arnold was saying. So certainly it's something which we are keen to look at. The issue, and I will turn to the second point, the issue, as always, is the political will, and then you know, this is why I talk about politically incorrect statements, because many member states are in front of me here, the political will to harmonise. Because I'm personally speaking here, feel there is a need for further harmonisation, and that is true also for the right to information. The IPRED was minimal harmonisation. What came out was what was agreed by the co-legislator at the time. On the whole, you know, there hasn't been enormously strong criticism of IPRED, and in fact, certain member states have said, please don't touch it. Certain practitioners have said the same thing because they fear that if you reopen a text like that, it could actually end up with a worse text than what you already have. I think that's a bit cynical. I think that if we've prepared our work properly and take the time to really evaluate the text and come out with the sort of arguments that Justice Arnold has said, I think we can be ambitious, but that's me speaking as a civil servant, not as a commissioner. but our political masters will have to make that call. But it's very, very important for the member states as well to recognize that. And what the gentleman was saying is about the right to information. Part of our preparatory work looks at exactly what's going on in the different member states. Not always easy to collect all the case laws, as you know, but nevertheless we are working on that. And it is true that certain provisions, if you look in certain jurisdictions, simply are not working. Now, why are they not working? It's a question of implementation, maybe. But it's certainly something, and I did mention the right to information, so you can rest assured that that will be one of the issues that we will be addressing. Thank you.
Justice Arnold, would you like to add to that, or no? Okay, good. Thank you very much. Do we have additional questions? Yes, please.
Yeah, my name is Bucura Ionescu. I'm from the Romanian Patent Office. I'd like to address a short question to the representative of the Commission. So please, if you'd like to detail or to explain, to expand a little bit more the allegation you have made on improvement of the transparency of patents. Yeah, thank you.
I think, correct me if I'm wrong, you asked me on the transposition of the directive. Was that your question?
Could you maybe repeat the very last sentence?
Sorry. As I noted, it was improvement of the transparency of patents. So maybe
transparency.
Yes.
Okay.
Okay.
Yeah. I mean, the thing I was alluding to is one, and in fact it comes to what John was talking about. In one of the areas where there has certainly been a lot of discussion, and it's also led to court jurisprudence, which has been very clear regarding injunctive relief, has been the issue of standard essential patents, which is an ongoing issue, as you know. We're not saying that we're going to certainly not harmonize in this area, but one of the key elements there has been how transparent the system is. Once you have a standard essential patent, these, you know, the list of patents which are covered, are they all essential? How can you bring more transparency to that issue? So that is one issue that we are certainly looking at, and I said there would be a number of measures next year, and we will try and come forward with this. This is not in any way to contest the need for standard essential patents, but it is clear that that has been an issue of contention, and it has enormous potential to, it's been, if I can put it this way, it's been very much to date been seen as a smartphone issue, if I can put it that way, you know. However, when you think of the importance of connectivity, and with the Internet of Things, it's now an issue that's going to spread and affect many, many sectors, European sectors, who are developing or using that connectivity, whether it's the car industry, but it could also be fridge manufacturers or house builders, etc. So what we want to ensure there is that there's better transparency to facilitate licensing, you know, which could become very large scale, and we would hope it would be in that field. So that's one, that was the specific reference that I was mentioning, and we're looking with the EPO and the standards bodies how we could improve that transparency.
Yeah, I do think the, I just want to interject a little, say the standard essential patents questions and what governments can do to facilitate their sort of identification and licensing, I do think is a very important place for governments to look at what they can contribute, either in terms of guidance or in terms of actual changes or developments of how the law operates. And part of the problem here for the standard-setting bodies is, of course, they want to try to get everyone they can to be involved in the process. And so often they don't want to put too much work into making things clear up front, because that will then raise the cost for people entering into the process. But then it has these kind of negative downstream effects when people can't figure out what was agreed to, what is exactly covered by this, and what those agreements actually mean. So I think governments, helping to intervene and set best practices and perhaps even rules might actually help substantially here. And another reason government intervention might be necessary is because when you have these standard-setting bodies, there are often antitrust or competition concerns as well, and they want to feel safe in terms of setting stricter rules for their members.
Yeah, if I could just add to this debate, I think we can all agree that transparency is a good thing. However, in this particular context, there are real problems. And what I would draw attention to in particular is that experience over the last few years has shown that national courts have very real problems in dealing with these issues. In particular because the crunch issue is always what is FRAND. That is the crunch issue. But what is FRAND depends on how the question is framed. Are we talking a single patent or a portfolio? Are we talking about patents covering one territory or a multiplicity of territories? And at that point, national court systems get bogged down. Now, the answer to that is arbitration. Because in an arbitration, you are not restricted by the geographical territory of the court, so it is possible to consider matters on whatever geographical basis the parties think appropriate. You're not limited by the number of patents that a court can realistically consider in one hearing, and so on. And so arbitration is a much more practical way of dealing with the issue of what is a FRAND royalty. However, the downside of arbitration is that for very understandable reasons, parties want to keep arbitrations confidential. So arbitration may be a much more practical way forward for the parties, but it enjoins a lack of transparency for others who are not involved in the arbitration. So there's a question mark as to how one deals with that. Now, in that regard, I would commend to your attention, for those of you who don't already know about it, an initiative called the International Licensing Platform, which has been developed in the agrochemical field and has been particularly pioneered by Michael Koch of Syngenta, along with others. And he's written quite widely on this subject, and if you haven't read any of his articles about it, I would strongly urge you to do so. It's a very, very interesting initiative in that sector, and one of the ways one of the things it tries to address is how you have transparency on the one hand and how you have efficient dispute resolution on the other hand, and in their particular model employing what they call baseball arbitration. And the evidence so far seems to be that it's proving to be quite successful, although it's early days.
Thank you very much. I have still 11 questions to ask, but I'm afraid we run out of time. So I'd like to invite the audience to join me in thanking this fantastic panel for all the great contributions. And with this and hope for a better IPR enforcement framework, I'd like to hand it over back to our moderator. Thank you.
Thank you very much. Ďakujem veľmi pekne odborníkom za cenné poznatky, skúsenosti.
Thanks to the experts for the experience, for contribution. Thanks for moderating, but I can't understand how you did not notice the charmant lady next to you. So it's time for lunch. We need energy because we have a couple of questions that we need to face in the afternoon. We will continue quarter to one, and we will talk about the trademark in the European Union. So please follow the time, and we will see each other later on. Quarter to two.
Dear guests, I believe that you've eaten good food and that you're full of energy to open another panel on the trademark reform in the EU. The discussion will be with regards to the benefits for member states and the European Union office. And the discussion will be moderated by the referendaire cabinet judge, Mr. Stets.
Thank you very much. I'm very happy, ladies and gentlemen, that we are here in such an important number of persons interested in intellectual property law. I must say that I'm happy to see faces that we saw in Alicante, Trier, Luxembourg, Brussels, Prague, or anywhere else, and that today it's Bratislava that is the center of the IP world for some days. I'm also very glad to tell you that we are in a historical situation which is important for trademark law, because, as you all know, the recent reform with the new directive or the amendments of the regulation, these reforms are considered as maybe the most important in the last 15, 20 years in the trademark law in Europe. Some of you might remember, some maybe not, but the first thinking of a community trademark at that time started in 1959, and the first proposals were from 1964. At that time, it was not even sure whether the system will be dual with national trademarks and a European trademark. But today, it is already a long time a clear situation where these two levels, these two components, are working together. And I'm very happy that we have here a panel of very, very well specialists who are in fact having their overviews from the practical and also theoretical side of view. And the panel is so composed that you have also persons from public, from private sector, and also from the European office, as well as from the national office. I will present to you, firstly, our keynote speaker, Professor Annette Kur. I am sure that you already know her because she has written a lot of books and articles in intellectual property law. I must say that I read a lot of them, so I'm considering to be a kind of taught by Professor Kur. She was for a long time at the Max Planck Institute as a head of unit and member of research staff. She's also affiliate professor at the University of Stockholm and honorary professor at the University of Munich. So she teaches also at the Munich Intellectual Property Law Center and is member of foreign faculty Santa Clara University. I could mention some other universities, including in New York, and many awards that she received. We are very happy to have her here for the keynote speech. After Professor Kur, we will have Mr. Jo Negrão from the EUIPO. He is, since 2011, the director of the International Cooperation and Legal Affairs Department at the EUIPO. And in fact, he joined the office in 2010 as head of the cabinet. Before that, he worked a long time in Portugal, the Portuguese office, also with the specialty of intellectual property rights, but also in the public administration on foreign affairs, and more generally also in the presidency of the Council of Ministers, to mention just some of his long and interesting CV. The third speaker will be Mr. Jan Lazar. He's from Slovakia. He is an attorney, junior partner, and member of the IPIT Commercial and Competition, EU and trade teams at Taylor Wessings, attorney at law here in Bratislava. And I must say that Jan won a lot of competitions already during his studies as a student. He was accepted to the Slovak Bar Association in 2012. He studied in Bratislava, in Cambridge, and he will give us the point of view also from the practitioners on the reform. And the fourth member of our panel, Mr. Imre Gonda, I'm also very happy to have him here, as I heard him speak very recently on an excellent speech about similar questions in Trier. He is from the Hungarian office, and he has been practicing national and international IP law for more than 15 years. He held different positions in the Hungarian Intellectual Property Office. Currently, he is deputy head of trademark, model, and design departments. So he works also in the practical part, but including on norm-setting procedures, so amendments of law and creation of new legal instruments. I think I would like also to mention that he was elected as a vice-chair of the WIPO Standing Committee on the Laws of Trademark Designs and Geographical Indications. He qualified in Pázmáry Catholic University in Hungary, and he also drafted a lot of books or other publications. So not to take any more of your time, I will give the place to Professor Annette Kurr for the keynote speech. Thank you very much.
Thank you very much for this welcome and the introduction. I'm very happy to be here, and I'm hugely impressed by the beauty of Bratislava, I have to say. I'm so happy that this event brought me here. I'm definitely coming back because, unfortunately, I have to travel back to Munich already this afternoon. Ladies and gentlemen, we have started today with enforcement. And it was said quite rightly that, well, indeed, usually it's the other way around, but there is certainly some justification for starting with enforcement because this is such an important matter and there are a lot of open questions to be posed in that regard. We are maybe only at the beginning of something which is an ongoing harmonization and unification process, and maybe we come back to those issues also in this panel. Now, one could say that maybe in contrast to that, trademark law is the least problematic issue in intellectual property because we are, well, we have already quite far-going harmonization starting already at the end of the 1980s and then really getting force in the 1990s. And this harmonization that we had already has been reinforced by the recent trademark package. So maybe here we have solved all the problems and everybody is happy, as the title of my presentation suggests, or maybe there are still some open questions. And what I tried to do in this 20 minutes that I have is giving you a sort of bird's eye view on what has happened and the reactions and maybe my personal view on what might still be lacking. So this is a timetable. Again, it started in 1989 when the trademark directive was enacted, but then it really gained force in 1969 when the community trademark system came into operation, and that was, by the way, also the year when the last of the member states who were then in the members of the EEC, namely Ireland, implemented the trademark directive. So we have a fully functioning system from 1996, so it's now 20 years. Then, for certain reasons that I don't go into much more, you see it here on the slides, the desire or the intent was born to revise the system in certain ways, and this has gone through certain phases. Also, our institute, the Max Planck Institute, was involved making certain proposals which were then taken up, at least in part, by the Commission, and then we saw the different proposals and procedures. And since March this year, we do have a new legislation. This was supposed to be underlined down here. I thought it would happen on a click, but obviously I didn't manage to do that. I said we have the new legislation since March this year, but there is still something to come, namely in 1st October next year, we'll see the coming into force of the implementing regulations and the delegated acts. So these will be complements to the basic regulation which is already in force, and these new acts that we are still waiting for, we see them now in the form of proposals. They will take care, or they will regulate a lot of administrative issues that are not as much in the foreground as the basic rules in the regulation, which are also important for the functioning of the entire system. Also, just as a side remark, when the implementing regulations and the delegated acts come into force, we'll see a new version of the regulation, which will be a consolidated version, which means that we then have to get used to new numberings of the provisions, not just in the directive, but also in the regulation. This is one of the, well, sometimes a little bit, I shouldn't say annoying things about European law, but you have to get used to new numberings in the both in the basic treaties, the Treaty on the Functioning, and also in some other acts, and that will also happen with the regulation now. Okay, so what was the result of the harmonization process? From the beginning, it was clear, and by the way, that was also already emphasized in the study that we did, that there is no need to reinvent the system from scratch. It is good, it was good as it functioned, so it was just about developing things further and to do some streamlining. So the motto was evolution and not revolution. We have, however, a lot of amendments or a lot of changes. If you look only at the number of provisions in the directive, you will see that they have nearly doubled. So there are a lot of new provisions, but the system is really, in its substantial elements, it has remained the same. Some of the amendments really do serve clarification issues. Sometimes jurisprudence by the Court of Justice has simply been implemented into legislation in order to make things crystal clear. I gave you, I could give you here in particular the example of the classification of goods and services, where the Court's IP translator decision has been implemented in Article 28 of the regulation. The Commission was, to some extent, more ambitious than what is reflected in the actual instruments, regulation and directive. They wanted to abolish national well, that's the second point here on the slide. First of all, they wanted to force national offices to examine for absolute grounds of refusal that obtained under the law of other member states, and also for obstacles that might result if terms that have been applied for registration in a non-EU language or in a non-EU script were translated or transcripted into EU languages. That would, of course, have been a very far-reaching burden on the national offices. It would have forced them to examine in all languages of the EU, and so it would really have destroyed one of the comparative advantages that the national offices have vis-à-vis the community office, the EU IPO, where indeed such a full harmonization taking account of all member states' languages has to be performed. So this was not accepted. The other thing that was not accepted was that the national offices should no longer be entitled to examine for relative grounds, that is, for the rights of prior rights of third parties. Here, the member states have made it clear that at least some of them, not the majority, but a sizable minority of member states still regards it as an important policy issue of their system, that they only grant rights where they can be sure that at least these rights don't conflict with prior rights that are found in their own registries, and they don't want to abolish, to abandon that policy prerogative. We have a high degree of harmonization now. Quite remarkably, this harmonization now also pertains to rules of procedure, which in the first directive had been completely untouched. It was something that was felt not to have any meaning for the functioning of the internal market, and so it was left to member states. Now we have entered a stage where it was found that for the advantage of users who may want to expand their rights, their national rights to other countries, having several national registrations, it would be of high value and concern that the procedural systems in the member states are basically the same and are aligned with the system that the users know already from the EU level. Then also very importantly, something which has been started already before the enactment of the package, namely the convergence program, the attempt to align the practices on a level which is not on the legislative level, but beyond that, the level on which the laws which are the same in the books then really are to be applied in practice. So alignment on that level should be encouraged by simply talking with each other, by having organized liaison meetings of the offices in Alicante, informing each other about the practices. This should be carried further. It should get a firm institutional framework to move on and go to even more tangible results. Also, but I'm only mentioning this in passing, one of the issues, the big issues behind the entire effort of the trademark package, namely the question how to distribute the revenues at the EU office has received a clear framework that reserves certain percentages of the revenues to go into common projects, another percentage going to the offices which, or to the national systems which after all take care of certain important issues of the common matters of enforcement, awareness raising, but also on the court level enforcing rights that were granted, or on the opposition level dealing with rights which are after all EU rights but which are treated in the national systems. Okay, so what are the reactions by users overall? The reactions, as far as I have come across, to users responding to what has happened was really positive. Well, one thing that is of course quite important from the user's point of view is that the fees, have been rearranged. They are now part of the basic regulation, and if you calculate them, you will see that all in all, the reform has led to a reduction of fees, in particular on the renewal level. Renewal fees are now the same as the basic fees. We have a certain modulation here in the sense that unlike previously, there is no basic fee which covers 3 classes. Each class must be paid separately, but if only one class is registered, then this is cheaper than before, and the same is even more so the case on the renewal stage. There are a lot of procedural things that have been changed in the basic regulation. There are too many to mention here, but the overall aim is indeed to streamline the procedures, to make everything flow a little bit smoother, and that seems to have achieved its goal. Okay, we haven't seen too much of it coming into operation, but users are confident that this will be really an improvement. Also, they welcome very much that transparency requirements have been posed, for instance, for the presentation of evidence by parties, if, for instance, in case that genuine use has been questioned. Another thing which was quite debated in the in the time before the legislation is the abolishment of the need for graphical representation. This as well is welcome because it opens the possibility to find new reliable ways of representation that are as clear and precise and durable, etc., etc., as graphical representation, but that is a better way of information than graphics would possibly be. However, the practical impact of those new means by now is not quite clear, or is probably rather small. It will play a role assumingly for sound marks, where sound recordings can now be the preferred way of representation, and also for movement marks, where of course video files can be deposited. This has not come. This is one of the instances where the new regulation still needs to be implemented by administrative rules. So we will see the effect of this only in October next year. Also, something which needs to be mentioned here, there is a system of certification marks which is available on the EU level. Many users have complained that they can only have certification marks in certain jurisdictions nationally, whereas there was a demand for such signs that give a reliable assurance of quality of some kinds for the entire EU. Also users, there are also some drawbacks. Some users say that the transition periods are too long, in particular for national systems to provide for administrative proceedings concerning opposition and cancellation. This is indeed something which has been set out for 7 years. On the other hand, but maybe we can hear more about that, some member states say, well, maybe this needs the restructuring of administrative procedures may need constitutional amendments, so that's not so easily done. There's another issue which has raised concern. There is this exclusion clause for functional products, certain products which derive, or shapes, until now it was shapes resulting from the nature of goods or being necessary to perform a technical function, or which give substantial value to goods. This clause has now been enlarged so that it can also apply to other characteristics than the shape of a product, and there is some insecurity about what this may mean in practice. And this uncertainty on the side of the users is also enhanced by the fact that the Court of Justice, by its recent jurisprudence, has shown that they are ready to apply those provisions that bar a trademark for good, so whatever kind of acquired distinctiveness the sign may have, it will always be barred from protection. So it would be very important for practice to know how far this can go, and here we have certain doubts. Scope of protection in double identity cases, this is something which also comes up time and again. Here we have the Court of Justice's functions jurisprudence, and many practitioners in courts say this is very difficult to live with. These definitions that the court gave us of the additional functions of a trademark that may come into play in double identity cases, they are very unclear, and we also don't know whether there are other trademark functions lurking in these cases, and we would rather want to know what we can rely on and what not. The Commission actually did make a move during the legislative phase in order to try to cut back the court's jurisprudence on the functions, but this was not accepted. We could discuss about the reasons. I basically think that the Commission proposal may have been well meant, but the way it was inscribed in the draft was not the luckiest one. If they really wanted to scale back the possibility to invoke trademark law in double identity cases, they should have done it a little bit differently. Okay, some have also, some practitioners that I've been listening to also complained a little bit about the removal of disclaimers from Article 37, second paragraph of the regulation. Why is that important? Well, they have the fear that it might be possible to register marks which are basically indistinctive and which just use one little figurative element as a figurative fig leaf, I think I can borrow the phrase from Mr. Justice Arnold, and then once they are registered, they would be then enforced against other configurations that just coincide in these non-distinctive elements, and having a disclaimer disclaiming already at the stage of registration the non-distinctive elements would help against this situation. Well, actually, we proposed abolishing disclaimers, so I have also myself to blame for that. On the other hand, when we asked at the office in Alicante about the use of that provision, they said we never use it, so it seemed that this was something which was itself a sort of fig leaf, which was not really operative. Yes, and then of course there's enforcement. We already covered that. That is a big issue because, as we heard before, law is only so good as it is then actually working in practice, which means as it can be enforced. And here we have simply the problem that the situation is still fragmented under national law. Academics are also normally quite happy with this. I have to say this because I am, after all, an academic. We are in particular happy about the enhancement of the catalogue of limitations and exceptions, the reference which is now made in the preamble to fundamental rights. However, a criticism from the academic side, and I think maybe also from a practitioner side, is that the enhancement of the limitations could have been a little bit more explicit, in particular with regard to referential use. We have it now in small c of the relevant provisions in the directive and the regulation, but it could have been more explicit that such referential use also covers parodies, criticism, comments, etc. Then we also have the discussion about the wisdom or not wisdom of the Commission's proposal to limit the protection in double identity cases. And finally, there is some concern about transit. This has been addressed this morning. We have now a provision that allows intercepting goods that are basically identical or essentially identical with something with, or bear a mark which is identical or essentially identical with a mark that is protected in the EU, so in other words, which are counterfeit goods. This as such might give an issue with regard to international rules, Article 5 of the GATT, freedom of transit. However, and that was not expressly stated this morning, there is a carve out in case that the person who is responsible for the goods can show that that it is possible to market them legitimately on the market of destination. So if that is shown, then the goods need to be released. Here is also the link with medicaments. I wouldn't agree that medicaments can never be touched. For medicaments, it should be rather easy to show that they have a market authorization in the country of destination, and only in these cases they should be released. Also, the clause, the specific clause in the preamble talks about marks that are very similar to INNs, the international non-proprietary names. So it's not every identity which makes things problematic. If a fantasy name of a pharmaceutical is imitated, then this is definitely a case of fake medicaments where interception doesn't pose any problem. Okay, my personal observations now, coming to the end. I'm quite happy, so I'm quite often asked, well, what do you think? You have been doing the study for the MPI. The Commission then made their own draft, so are you happy? Are you unhappy? Well, it's not really something it's not my task to comment on anything that the Commission does or did not do, but what I can say is that I think that the package as such is really a good thing. It improves a lot of things. So I don't see that anything is negative about it. The only question is whether it could have been more positive. And here, I personally would have been happy to see a little bit more of clarification. I already addressed limitations and exceptions. But also, I think there could have been a little bit more, even in the preamble, to guide us, or in situations where it is very likely that problems may accrue. And then, of course, enforcement. We heard that before, so I just can refer you to what we said this morning. When it comes to the preamble, I just want to name two things which I think would have been relatively easy to point out, and actually these are things that we actually did propose, namely, first of all, right into the preamble that likelihood of confusion cannot be based on elements which are descriptive or non-distinctive as such. If that would have been done, then this renouncement to disclaimers, with disclaimers being non-operative anyhow, would have been a good way to solve these figurative fig leaf cases, I hope. Next thing that I would have liked to see is simply make it clear that in double identity cases, trademark law applies. But it only applies in case that a trademark is used in order to refer to a mark as being the distinctive sign used for the products of the proprietor. In those cases, infringement would only occur if there is a manifest encroachment on the interests of the trademark holder, namely when it is incompatible with honest practices. If that simple phrase could have been pointed out in the preamble, maybe it would have taken away this need to discuss functions, which I also realize is something which is very unproductive. The formulation used by the court is really confusing rather than clarifying. So if it were clear from the beginning, okay, if there's double identity, the trademark law applies, but then we have to look into the case and see whether it is incompatible with honest practices, and in particular when now that we have an enhanced catalogue of limitations, that would be a much more feasible and pragmatic way to address these issues. Enforcement, again, maybe 2 words, if I may. There was indeed a suggestion, at least in Germany we had a full-fledged suggestion being made by the IP Association for provisions on sanctions to be taken into the EU TMR. However, that proposal was simply based on what is already in the UPCA. So the UPC agreement has certain rules on enforcement, and the proposal was simply to emulate, to just copy-paste these rules into the community, the EU trademark regulation. As we have heard this morning, the rules in the UPCA are also deficient, so we don't have everything that we need in there. So instead of simply copying those rules, which are themselves copied from IPRED, and IPRED is far from comprehensive, I would think that would be much better to start thinking about a good and balanced set of rules which also covers the issues that neither IPRED nor the UPCA covers. And those rules, I hope, would then also be balanced in the sense that they also take into account the countervailing interests of those who are targeted by infringement claims, because we still have a little bit of the tendency that we always talk about the infringers and how bad they are and how much damage they do. There's also much damage on the other side potentially. If SMEs or also others are seized by an unjust claim for infringement, this may ruin a lot of their investment, and I have not seen until now a serious study, actually asking for the, the freezing of efforts and investment that occurs by claims being filed without a proper justification in the law. So I would really like both sides to be considered equally. Certainly that has to do also with a proportionality principle, but that is something that should be elaborated a little bit more strongly. This was what I tried to summarize my impression about what has happened in the trademark field. Thank you very much.
So thank you very much. I think we now understand very well that it was a great opportunity to listen to one of the persons who know a lot, maybe, of the profound reasons of the trademark reform, because as we heard in 2011, the Max Planck Institute was already preparing the reform. Now I would like to give the word to Mr. Nigrao from EYPO, who will speak from the office's point of view and also specifically more on the regulation. So thank you very much.
Good afternoon, ladies and gentlemen, dear colleagues. Allow me, first of all, to thank the Slovak presidency and the Slovak office for the kind invitation addressed to the office to be here today with all of you to discuss these interesting matters associated with the long-started trademark reform. I will try to give you an overview of the main changes brought about the reform. I'm going to overlap a little bit, of course, the presentation from Professor Anik Nur, but that will be inevitable. But I will try to give you an overview of the main changes that were brought by the reform in trying to answer those 4 questions: why, when, what, and how. Regarding the why, the main objectives of the reform, as set by the European Commission, could be summarized as, I see them in 3 main objectives. First, this was the first comprehensive overall reform of the EU trademark system in 20 years. So this was, of course, a great opportunity to look at the system from, of course, the broad picture and try to improve a system that was already working quite well, and always, of course, for the benefit of the users of the trademark system. So the first objective set by the Commission was to foster innovation and economic growth by making the system more accessible and efficient for European business in terms of costs, naturally, increased speeds, greater predictability and legal certainty, all issues that are of the highest importance for the users of the IP system. Secondly, to provide a formal legal basis and secure a sustainable source of funding for the cooperation with national offices, cooperation that was already established for a number of years, but that needed to be systematized in a specific framework and to be supported also financially from the office budget. And thirdly, to align certain aspects of the office governance to the Lisbon Treaty and to the EU common approach on decentralized agencies. In what regards the when, we know that there are mainly 2 key dates in this process. We all know that the process started in early 2007 with a communication from the Commission aiming at reinforcing the IP system, and then we had continuous discussions in the Council of Ministers regarding fees and budget. There was a decision to entrust the Max Planck Institute with a study that was carried out in 2010-2011, and that was the basis, naturally, for the proposals that the Commission put forward in March 2013. So I would say that is the first key date for the process, the proposals from the Commission for a new trademark regulation, but also for a new regulation on fees and for a new trademark directive. The objective here would be to have a comprehensive approach to the system and making sure that the provisions that would be decided and included, incorporated in the trademark regulation would mirror the same provisions that would be decided and included in the trademark directive. There was only one major objective doing this exercise, which was to achieve higher levels of convergence, of harmonization between the EU system and the national system, something that is fundamental before we start cooperating at a technical level in a more intensive manner. It is to have a framework that is quite consistent, harmonized and convergent between the EU system and the national systems. Naturally, the second key date, in my opinion, in this process was the 24th of December 2015, with the publication of such texts. Of course, you know that in the meanwhile, the fee regulation was introduced and included in the new trademark regulation. So as from now on, fees are included in the EU trademark regulation. And with the publication at the same time of the regulation and of the directive, this first objective, in my opinion, of bringing higher levels of convergence and harmonization was achieved. Now turning to the what. What are the main substantive changes brought by the reform? I would like to group them in 8 major areas, the ones that you can see in the slides. Formalities and examination proceedings, exactly the first and the core business of the office, the most important area in what regards trademark proceedings. Absolute and relative grounds of refusal, goods and services, also quite relevant, appeals, fees, governance of the office and cooperation. So you can see that the reform not only introduced changes in the field of trademark practice. It is true that the vast majority of these changes can be found in the trademark practice. But there are also important areas such as governance of the office or cooperation framework that was created with the amended regulation that complement all the elements of the reform. Let me give you some examples of changes that were brought within these 8 areas. In the area of formalities and examination proceedings, one of the most relevant novelties is that the capacity to act before the office is extended to users and representatives from the European Economic Area. And here I'm talking about Iceland, Liechtenstein and Norway. Also in that area, it is worth mentioning that even though the procedure of searches, as already mentioned here before, and surveillance letters was not finally abolished, as proposed by the European Commission, it has been simplified and disconnected from the inflexible deadlines that delayed the whole examination procedure. So the objective of efficiency and speed in the process has also been achieved. In the area of absolute grounds, let me just mention 2 of the novelties. First, the abolishment of the graphic representation. I will mention it a bit later when we will talk about secondary legislation, but this is one of the key points of the reform. Secondly, the functionality, also here already mentioned, and other characteristics. The reform follows the recommendation of the Max Planck Institute study and the practice in other relevant jurisdictions, such as the US, and extends the prohibition that currently applies to shape marks, also to signs consisting exclusively of other characteristics, such as color, smell, or sound. Now turning to the area of relative grounds of refusal. In this area, one of the changes which shows the link between the European Union trademark system and the international sphere relates to the opposition period for international registrations designating the European Union, Article 156 of the revised regulation. The period of opposition against international registrations designating the Union now begins 1 month instead of 6 months from date of publication of the international registration. The reason for that previous longer period was the time needed to draw up the search report, which now can be completed much earlier. Again, the objective of more speed, more efficiency was also taken into consideration with these changes. Another one is the existence now of a specific ground for protected geographical indications and denominations of origin. A specific ground is introduced, although such ground was already included within the other signs mentioned in the existing Article 8.4, but it's now made explicit. It has been in the area of goods and services that the legal reform has brought one of the changes which has given rise to more comments and discussions, at least with the users of the systems. And I refer, as you may guess, to the new Article 28 of the amending regulation. The reform follows the line established by the ECJ in the IP translator case by requiring the goods and services to be identified with sufficient clarity and precision to enable the competent authorities and economic operators on the basis of the specification alone to determine the extent of the protection of the trademark. This was one of the key elements identified by the Max Planck Institute, and it was also taken in board during the negotiations of the revised regulation. What does that mean in practice? On the one hand, the Office will only accept the use of general terms provided that they comply with the requisite standards of clarity and precision. On the other hand, when such general terms are used, including general indications of the NIS headings, they will always be interpreted according to their literal meaning. These are all criteria and references that you can find in the IP translator decision of 2012. In respect of appeals filed before the Office's boards of appeals, with the new amending regulation, the interlocutory revision in inter-parties has been eliminated. This is Article 62 of the former CTMR. The interlocutory revision of first instance decisions in inter-party cases was possible only in very exceptional instances, since it required the agreement of both parties. Hence, the legislator has chosen to eliminate this step, which would result in shorter proceedings in inter-parties. So there is also here the application of the principle of economy, also here mentioned, that provisions that are not effectively used and do not represent an added value to the users have also been eliminated from the European Union trademark regulation. Last but not least, mediation centre. The reform gives the Office the possibility of establishing a mediation centre for the friendly settlement on a voluntary basis of inter-party disputes based on EU trademark regulation and the regulation on community designs, both at first instance and appeals level. And this is something that I also heard here in the morning referred by the representative of the European Commission as one of the main achievements of this reform. In what regards fees, fee structure and fee levels. Following the comments made by the majority of users' associations in the context of the Max Planck study, and in order to reduce claims for goods or services not really corresponding to the business needs of the applicant, the reform provides that an additional application and renewal class fee will be payable to each class beyond the first and not the third, as previously happened. As regards the actual amounts, the reform will result in an overall reduction of the fees payable to the Office. Again, this was one of the objectives of the reform, the reduction of costs for the users of the system. Renewal fees, naturally, have also been reduced with the reform, as well as opposition fees, appeal fees, and so on and so forth. So overall, we can say that there is a huge reduction of costs for the users of the trademark system. But I also mentioned in the beginning that not only trademark proceedings have been touched with the discussions on the trademark reform. Also issues associated with governance of the Office, such as changes in the composition and functioning of our governing bodies have taken place. For instance, the European Commission is now a full member in our management board with 2 representatives, each one of them with voting rights. And this happens also with the European Parliament, since the European Parliament is also representative in our management board with one voting right. This is totally aligned with what was decided by the three institutions, the Council, the Parliament, the Commission, in the interinstitutional agreement on decentralized agencies. Also, the election of senior officials has been clarified in the basic regulation with clear mandates, extendable ones for the executive director, deputy executive director, president of the boards, and so on and so forward. So this is something that also the legislators felt the need to introduce with more clarity in our basic regulation and to adapt it to the recent decisions by the three institutions of the European Union. In terms of budgets, you might remember from the previous speech that budgetary issues were at the beginning always of these discussions, and the fact that the office had accumulated a significant surplus during the first, let's say, 15 years of its activities, and also in terms of budget and with the objective of balancing the budget of the office, at least two instruments were introduced by the reform here. First, a compensation mechanism to member states for tasks that member states carry out within the European trademark systems in Europe. These tasks could be tasks of providing information to the users of the system, but not only, also contributing in tasks related with enforcement, which is of course something crucial and that has to be addressed also at national level. So there is a logic here in terms of a systemic approach to the different roles and tasks, both of the European office and the national offices, with a financial mechanism that supports in a stable and systematic manner this division of tasks and competencies. Even also the possibility to exceptionally transfer parts of the budget of the office to the budget of the Union. Under a certain number of conditions, this can be decided by one of our governing bodies, the Budget Committee, which is the budgetary authority of the office. So this is now a reality, and we hope sincerely that this mechanism not only will allow member states and the EU IPO to cooperate better, because they will have the means in a systemic way to cooperate better for the interest of our users, but will also allow the budget of the office to be better balanced and to better distribute the resources generated by the system itself. Cooperation activities, yes. It is true that since 2010, at least, the office established, together with the national offices of our member states, a very clear and comprehensive cooperation framework through two main programs. A cooperation fund aiming at creating common tools that would be used by the European office and by the national offices and made available to the users, that will entail 21 tools that aim at modernizing all the offices, IP offices in Europe, and a convergence program that aims at approximating the practice of the national offices and the EU IPO. The objective here is to provide with the users a more user-friendly system, provides higher levels of legal certainty, and to foster, of course, protection of IP in a non-expensive manner. I think that the regulation here introduces a mechanism that is fundamental to support the continuation of such cooperation. Article 123C foresees the possibility for the Member States and the EU IPO to cooperate in the areas of the convergence of practices and tools. For this to happen, the users of the system will have to be consulted before any such project should be launched and adopted by our governing body, the Management Board. So you see that there is clearly an involvement of all relevant entities in this cooperation effort that in fact will use or reuse the available resources of the EU IPO and put them, of course, at the disposal of a cooperation effort that should generate a concrete benefit to the users of the trademark system in Europe. The Office can support this cooperation to the maximum extent of 15% of its income. And if you think that the income of the Office is of more than 200 million euros a year, this is quite a significant amount that is dedicated or that can be dedicated upon approval of our governing bodies to cooperation. So we expect, of course, this cooperation framework in the years to come to be reinforced, systematized, streamlined, and to continue to generate benefits for our users. I said that this would not be, of course, the 24th of December 2015. It is not the end of the story still, since there are still secondary legislation, delegated and implemented acts that will have to be adopted before October next year in order to have the reform completed. I will not dwell into great detail in these delegated or in these changes proposed through delegated and implementing acts, but I would like just to highlight some of them already here mentioned: elimination of the graphical representation requirement, something that it's one of the key elements of the reform, and I would say that it is fundamental that the national offices, and also in this case the EU IPO, are able to offer a converged approach in terms of what will mean this new provision for the users, in order to avoid divergence from the beginning and to avoid, of course, having to then launch a convergence program in this area. It is a very new area, so the proposals that were put forward by the Commission, we consider them to be excellent. We think they are the excellent departure point to be discussed with Member States in this regard. I would like, of course, to see these discussions finalized as soon as possible so that we can all, with the national offices, start to work together in terms of defining the common practice that we will apply in terms of graphic or in terms of what will be the representation of trademarks as from the 1st of October 2017. Introduction of EU certification marks, already here mentioned by Professor. Changes in the register, also aiming at streamlining and simplifying the register. Assignment, which is of course an important element. It is now possible to assign in favor of the owner a trademark that was filed by these agents without his consent, or to oppose the use of trademarks by his agent or representative on his favor. These are all necessary complementary provisions that will complete the reform by the 1st of October 2017. Last but not least, I'm not going, obviously, to dwell into the proposals that were introduced by the directive. That will be done, of course, by my colleague in the panel, but I would like to say that the directive exactly mirrors the same provisions that were adopted for the regulation. And that is a huge achievement of the reform, in my view, because that will create us the necessary conditions to continue to converge from now on. Because without, of course, these basic conditions, it would be very difficult to try to approximate our practice, to try to approximate the way we work in order to offer the users with a more simple and streamlined procedure. These are basically the change that you can see also in the trademark regulation. So the ones that I've mentioned, they are all here, of course, also included in the new directive. Of course, on top of that, you have also administrative procedure for invalidity and revocation of trademarks for the Member States, which is something quite new that we also believe will contribute greatly to the improvement of the system. So, in conclusion, and not, of course, wanting to take more of your time, I think that the reform, first conclusion, is not completed. We need to continue to work hard in order to have it completed by the 1st of October 2017. From the side of the office, we are collaborating very closely, and I think in a very satisfactory manner, with the European Commission in order to have the best possible delegated and implemented acts enacted by the 1st of October 2017, but we think that a number of the proposed objectives by the European Commission in the beginning of the process have already been achieved, and we should continue to strive to complete the rest of it until next year. Thank you very much for your attention.
Ďakujem. Myslím, že to bolo extrémne zaujímavé. Úrad duševného vlastníctva na tému reformy známkového práva. Teraz by som požiadal pána Jana Lazura, junior partnera, aké sú hlavné zmeny a ako ich môžeme vnímať. Dobré popoludnie, dámy a páni, drahí kolegovia. Prvne, než začnem, rád by som sa poďakoval organizátorom tejto konferencie o duševnom vlastníctve. Je to skvelá príležitosť podeliť sa o myšlienky a skúsenosti v rôznych oblastiach duševného vlastníctva. Je pre mňa veľkou cťou, že tu dnes môžem byť. Tu sa zaoberáme ochrannými zámkami a nedávnou reformou obchodných známok. Budem hovoriť o zmenách z praktického hľadiska. Zvlášť budem hovoriť o neoprávnenom použití, ako aj o obmedzení a obhajobe, ale taktiež o zmenách v poplatkoch, pokiaľ ide o prihlášky, ktorú sme už uviedli viackrát. Ako výsledok tejto reformy máme niekoľko nedávno formulované formy porušenia, vrátanie smernice. Tieto neoprávnené použitia sa zaoberajú používaním označenia ako obchodného názva spoločnosti alebo ako súčasť obchodného názvu alebo názvu spoločnosti. To znamená, môže sa využiť ako obchodný názov alebo ako súčasť obchodného názva. Teraz je to potvrdené. Teraz je to už potvrdené, že sa to bude používať za porušenie alebo neoprávne používanie ochrannej známky. Už nie je potrebné analyzovať, či značka je použitá len pre označenie obchodu. Ak sa používa ako obchodná značka, doteraz to bolo v praxi veľmi zložité. Teraz sa to bude považovať za neoprávnené použitie. Preto by sa podniky mali uistiť, že nevyužívajú vo svojej obchodnej značke iné ochranné známky. A neskôr vysvetlím, toto sa vzťahuje aj k faktu, že použitie súkromnej značky neuchráni spoločnosť od žaloby v súvislosti s neoprávneným použitím. Môže to byť len oprávnené. Registrovaná obchodná značka môže byť teraz napadnutá, ak dôjde k jej neoprávnenému použitiu. Tam, kde existuje riziko balenia, etikety, fisačky alebo pravosti, môže dôjsť k neoprávnemu použitiu, preto je potrebné bojovať proti falšovaniu, je potrebné prijať
A trademark owner now has the right to prohibit affixing such a sign, affixing a sign which is identical with or similar to the trademark on packaging, labels, or text, and to prohibit offering or placing such items on the market. The same rules apply also to authenticity features and devices as well. The problematic question of goods entrusted through the EU, which was already mentioned, was one of the major matters addressed by the EU trademark reform. According to the former rules, the IP right holders had to prove that the goods in question were actually intended for the EU market. In the important Philips Nokia case, it was held that the customs authorities of an EU member state may effectively detain goods in transit only if it is proven that they are intended to be put on sale in the EU. The customs authorities could only stop the goods in transit if they had a reason to believe that the goods would be diverted into the EU market. In practice, such a position was considerably unfavorable towards IP right holders. Under the new rules, the European customs authorities will be entitled to detain also goods in transit, this time for third countries. However, EU trademark owner will not succeed in proving infringement if the declarant or the holder of the goods proves in court that the trademark owner does not have the right to prevent the use of such identical trademarks in the country of destination. The burden of proof is now put on holders of the goods. To defend themselves from infringement claims, these holders need to prove that the goods are not infringing. It is not the trademark owner or the customs authorities anymore who would need to show that the goods are intended to be placed on the EU market. It needs to be stressed, however, that these new rules apply only to obvious cases of trademark infringement. The suspected goods must bear a sign which is identical with the registered trademark or a sign which cannot be distinguished in essential parts from the trademark. Therefore, customs authorities will be entitled to detain goods based on the suspected trademark infringement. However, if the detained goods are subsequently found not to infringe, the trademark owner will be liable for damages. These changes are contained also in the Trademark Directive, which includes analogical provisions about goods in transit and the burden of proof. The EU member states need to implement and transpose these changes by January 2019, and it is to be seen whether the EU countries will wait until the end of this period or whether these rules will be implemented earlier. Until these changes are adopted by all EU member states, there will be certain dichotomy between the transit rules applicable to EU trademarks and the transit rules related to national trademarks. It seems that the owner of national trademark will still need to prove that the goods in question are intended for the EU market. So for the whole European market, it will be much more positive if the rules are the same for European trademark as well as for national trademarks. It is now also specifically stated that using the sign in comparative advertising in a manner that is contrary to the EU Comparative Advertising Directive constitutes an action which is prohibited under both the new Trademark Directive and the EU Trademark Regulation. This clarification adds another hurdle to all businesses wishing to engage in comparative advertising. Due to the strict regulation of comparative advertising on a number of occasions, we have seen that the companies that were initially eager to challenge their competitors through comparative advertising eventually decided not to proceed that way. Sometimes we have clients who want to actually start some comparative advertising campaign, but when we notify them of all the rules they need to be compliant with in order to be clear, they say, okay, this is too risky for us. So in practice, it's very rare that the companies who consult lawyers will go through this way. Let me now move forward to the changes in limitation and defenses to infringement. The so-called all-name defense has now been considerably restricted. Under the amended rules, the all-name defense will apply only in cases where the defendant is a natural person. Legal entities will not be entitled to shield themselves from liability by referring to the use of their company names anymore. The European Council and the European Commission issued already in the past a minute or a statement in which they claimed that these defenses shall be available only to use of personal names and natural persons. However, in the very well-known Anheuser-Busch case, the ECJ held that the minute is not binding and there was nothing in the directive which would suggest such limitation. Now, which is quite curious, the initial position of the Council and the Commission has been basically reflected in the wording of the directive and the regulation. Given this change, it is now very important that legal persons and companies become aware of this amended situation. Before selection of a company or trading name, clearing searches should be carried out in order to ensure that company names do not infringe any third parties' rights. This would minimize legal risks that could arise due to this situation. In comparison to the previous rules, the defense of descriptive use has been amended in order to cover also the use of signs which are not distinctive. Therefore, a third party who uses a sign which is of a non-distinctive character will be able to avoid the risk of possible trademark infringement. In line with the wording of the new directive and the new EU trademark regulation, the uses made by third parties to draw the consumer's attention to the resale of genuine goods should be considered fair. This will apply in cases where the genuine goods have been originally sold by or with the consent of the trademark proprietor. Apart from that, uses made by third parties for the purposes of artistic expression, commentary, and criticism, as well as parody, should also be considered fair and not infringing. And also, at this point, I totally agree with what was said before, that all these defenses could be more specific and more clear, because eventually we'll perhaps end up before the European Trademark CJEU to decide whether the particular action is or is not in line with those limitations and defenses. This was a very brief overview of the changes made in the infringing uses and in the limitations and defenses. However, what is already having direct effect on trademark applicants is the new structure of application fees. Also, this topic has been mentioned several times, but it is really the point which we see very, very often in legal practice, that everybody wants to know, and each client wants to know what is the current value or the current amount of the fee they will pay for registration of their trademark, and they then decide whether they want to have a European trademark or a national trademark, and the fees are really an important point they consider. I am personally very much in favor of this policy where the basic fee covers only one class. In practice, it was very rare to see trademark applications where only one class was actually claimed. When more classes were covered by the basic fee, it was almost a rule that no applicant claimed only one class. Now the applicants need to decide whether they are actually willing to pay additional fees for additional classes or not. Considering the limited amount of time we have, I will not go into further details about the fees, and I would like to thank you all for your attention. Thank you.
Ďakujem veľmi pekne pánovi Lazurovi za vynikajúcu prezentáciu z pohľadu praxe. Teraz hneď odovzdám slovo Imremu Gondovi z Maďarského patentového úradu, ktorý tiež bude hovoriť o smernici aj o nariadení z pohľadu úradu, ktorý sa s týmto potýka. Ďakujem pekne. Dobré popoludne, dámy a páni. Dovolte.
My gratitude to the Slovak presidency and the Slovak IPO for the kind invitation. So ďakujem pekne again. And I'm also most grateful for the set or the sequence of presentations, because that brings me the comfort, since almost all important areas has already been touched upon, because you had the possibility to listen to excellent speakers who highlighted different approaches from academic circles, such as the Max Planck Institute, but also we've heard the approach from the EU IPO and the user side. Mainly focus was on enforcement. What was left to me is to say a few words about the point of view or the considerations of a member state if it comes to implementation of the trademark directive, including the transposition. Transposition is a legal exercise which is by no means an easy one, but the most difficult part of it is perhaps to look into the practice and the possible implication that may have on it. But before doing so, may I draw your attention to the structure of the presentations. I do hope that I'm using the right button. Yeah, that's it. And since I have quite a limited time, and since our previous excellent speakers already highlighted some of these elements, therefore, with your permission, I will skip some of the slides. But I think it's still worth to look into the past, the way what led us to the European trademark reform. And then I will highlight some of the practical aspects of the transposition or the implementation of the trademark directive. Let's say 5 or 6 aspects I can show you here. And finally, I will make a try to draw some of the conclusions. Well, the timeline has already been explained by Professor Kur quite in depth, and I will just draw your attention to 2 simple aspects here. What was the reason for the review? The first one is the age. If you look at the dates when the trademark directive was adopted or the European trademark, the community trademark regulation, it was over 20 years ago. A lot of developments we see in between, also in terms of business strategy, marketing tools, IT tools, and consumer behavior. And certainly there was a need to review the whole system. And the second has a rather political aspect, that is a nature that was the constant fee reduction of the EU IPO, or under the previous name OHIM. Which is basically good for businesses and good for, especially for small and medium enterprises. So you may raise the question, what is the problem with that? The problem is that if it achieves down to a level, then it may interfere with the proper operation of national systems. And one of the basic principles of the community, nowadays we call the European trademark system, is complementarity or coexistence. And after an amount, the users of the system won't be driven by their business needs, namely the scope of protection for the trademark, but the levels of the fee. That's why in 2007, certain member states agreed on the fee reduction with the condition that the whole system should be reviewed. I think I will skip this one. The package, the expression we use, was used just to express that there was a very clever approach to review not only the community trademark regulation, but the trademark directive, plus elements of the secondary legislation as a whole in the same time, because there are a lot of interdependencies. Objectives, we've heard quite a number of it. These are the original objectives highlighted in the basic proposal made by the Commission in March 2013. There are a lot of interesting elements there and a lot of similarities between the objectives for the reviewed directive and the European trademark regulation. I think among the 4 for the directive, perhaps the most straightforward is the harmonization of procedural law, because in that area not much has been done in the past. Perhaps at the late 80s it would have been too much ambitious, but I think especially for users this is something really valuable. It is highly important to listen to the voice of the users at the beginning of the exercise when the basic proposal is available, but I think it might be also important to listen to them when the European trademark reform has been adopted, but before the national authorities start to transpose it, so member states start the transposition, because not all the provisions of the directive are compulsory. There are some optional elements. Plus, it might be also important to see where they see the risk of misinterpretation of certain provisions, and to identify areas for convergence and taking advantage of the already existing cooperation schema with EU IPO. I think it might be an important input for all of us. And our office is also planning to organize early December a user meeting, for instance. Well, this will be one of the points on the agenda. And now my subjective list. The first element on it is the non-graphical representation of marks. Well, here again, this is, technically speaking, quite a straightforward solution to get rid of the graphic representation and to move and to open the door for an IT-based representation of science, because IT is developing and the expansion of use of internet and certain forms of internet is quite obvious also in the area of commerce. But on the other hand, it's so funny to see when trademark experts are coming together and this topic is simply just appears. Everybody's getting very exciting. Oh, non-traditional trademarks, that's so interesting. So there's suddenly a very lively debate on it. But if one would look into the statistics and on the proportion of such types of trademarks, they represent less than 0.5% of all applications in Europe. So even though it's a very interesting topic, it has a very little impact on the real practice, as Professor Kur just mentioned, but I don't want to be pessimistic. Maybe in the near future, with this new option, the number of such trademark applications will go up to 1.5%. I don't know, it might be. But we never know what the future will bring us with the extensive use of IT tools. What might be extremely difficult on the level of practice here, to define the requirements of representation of a sign. Okay, it should not be represented graphically anymore, that's fine. And according to Article 3 of the directive, the subject matter of the sign itself should be clear and precise. This is not giving us further detail on the issue, but in the secondary legislation, we are hoping to see much more details in terms, for instance, of IT technology or any kind of guidance. Where should be the limits for presenting the trademark, the mark in itself. And certainly this could be a highly interesting area for convergence, because no matter how we agree on the level of principles, it would be useful to interpret the provisions in the same way on national levels as well, because of the large number of interoperable elements. And that's why it could have been an excellent subject matter for a new convergence project, but unfortunately, or luckily, the secondary legislation is still going on, and we're hoping to get some guidance from there. And the time frame for a convergence project is much larger, so they would not necessarily end before October 2017. So what remains for us to wait for the result there, and then to see how can we converge the practice. Well, in which area is convergence of practice may be interesting? Obviously, e-filing, e-register, and trademark search. But at the end of the day, if we agree on a common solution here in Europe, it's not necessarily enough, because you should also bear in mind the linkage with the Madrid system. And under the Madrid Agreement and Madrid Protocol, currently we have 96, 97 member states, and you should also bear in mind the different level of technical developments. So if you agree on a very high IT standards here in Europe, then you may also limit the options of your clients, and they cannot take advantage of the international registration, because third countries cannot be easily accessible. For those scenarios, the description could be a good solution. Description is a well-founded concept, for instance, in patent law or in the area of utility models, but it's a complete alien for trademarks. And unfortunately, the legal value of a description for such a non-traditional trademark has not been defined on the level of the directive, neither on the level of the community trademark regulation, and according to the drafts we have for the secondary legislation in the EU, where the content is not clear either, because one of the provisions says it simply serves explanatory purposes, while the other says it may specify the subject matter of the protections of the sign itself. So I think this is a contradiction that should be solved in the near future. All right, and I think that one of the way out might be the cooperation with EU IPO and other IPO offices, including the Benelux as a regional one. Expanded functionality. Here again, this is a tiny change, but it may have a huge impact on the practice. Because as you may have noticed, with this change, that particular ground for refusal, that absolute ground for refusal, is not limited to three-dimensional marks anymore. But it's also applicable for verbal marks, for sound marks, for figurative two-dimensional trademarks. Well, if you would ask me what kind of examples can I give you outside the area of three-dimensional marks, I could perhaps say that the noise of the motorcycle Harley-Davidson, where they have a large V2 engine, and that particular sound is quite related to the technical solution. Maybe the example is wrong. Or another example might be the color combination of yellow and black for certain hand tools. This is what I can think of, but obviously we don't have a practice yet on it. What might be particularly interesting for the practitioners and also for IP offices, that this ground for refusal cannot be circumvented by the good old argument of acquired distinctiveness. While something that is descriptive but widely extensively used can acquire distinctive character, but for this one you can't do it. So once you receive an objection from the office, it will be very difficult to convince the office by using regular argument that the trademark is still protectionable. Furthermore, what might be also interesting on both levels, on the community or European level and also on the national one, that transitional arrangements are missing. Don't forget that this is not only a new ground for refusal, because for that you don't have much problems, since the new law will enter into force in the member states as of January 14, 2017, and this will be applicable to trademark applications that have the filing date the same day or later one. But what will happen with cancellations? Because technically speaking, this is a new ground for cancellation. And here we have at least two conflicting basic principles. The one is the prohibition of retroactive effect. Once it may have an impact on something very basic legal principles, such as the protection of property. While the other parties, they may say or claim that, we cannot simply rely on old-fashioned principle that only those grounds for cancellation can be invoked that were valid on the date of application of the trademark. Because in certain countries, for instance in Hungary, we may go back to 1890, and it would be something obsolete to limit the grounds for cancellations to those grounds that existed on the same day. Even though, here again, I do understand that number of trademark applications that may be related to this difficulty is quite limited, but in theory, trademark is a very special species in comparison with patent, for instance, because the term of protection is unlimited in time. I mean, you can renew it every month. We had already a similar experience in 1997 when the new Trademark Act entered into force in our country, and it introduced new grounds for cancellations. And one of the cases, I mean, the reference went up to the Court of Constitution, but it was slightly different because finally the Court of Constitution, they said it's fine to apply such new grounds for cancellation even for those trademarks that has an earlier filing date, because the particular ground for cancellation was, according to the practice of the court and the office, already incorporated or very closely related to those grounds of cancellation that existed before the revision. But I think in this case, this is something completely new, and this is something that we should bear in mind if it comes to the real practice and to the transposition. Well, as I said, this is quite a straightforward solution of the reviewed or revised trademark directive, namely that its ambition was to harmonize procedural law and the introduction of opposition on the national level. I think this is quite a good solution, even though it could have been more ambitious in my view. But anyway, this is something really interesting. And of course, the deadline, I think the time period given to member states is long enough to transpose these positions. What is perhaps more interesting for users is the introduction of administrative cancellation and revocation. And here we've heard some of the voices from users that 7 years is too long for the implementation or transposition of such a provision. But don't forget that in certain member states, these procedures fell under the competence of the court. And it's not that easy to change it. In some cases, it may be also interrelated with the constitution of that particular member state. So 7 years might be enough, but in under certain circumstances, it might be even a short period. Well, for us, it's not a difficult exercise because we have the long tradition of having cancellation and revocation on the administrative level. And we introduced opposition on the same day when the country acceded to the European Union. Well, classification. But I think if you would like to be more precise, we should say specification. Because with the class heading, it was never the problem to which class it belongs, but how shall we understand the scope of it. Here we have the well-known IP translator case. And basically the first two answers delivered by the court in that case was quite clear. General indications of the class heading means what it says, but according to the third answer, it was rather unclear, because it said when the client or the user is indicating all the general terms in the class heading, then the office or the national authority should also know what was the intention of the user. And in certain member states, it was interpreted in the way that once this is indicated, the office should ask the clients. So for instance, our office followed that approach so far. With the reform, this situation has been clarified, and I think that the solution applied in Article 28.8 for the European Trademark Regulation was quite a correct one for users. So within 6-month period, they can clarify what was their intention back in the days. Nothing similar exists on the level of Trademark Directive, but I think it means for us that this question is left to the national legislator, so they can allow for a similar solution. But there is another aspect that may be interesting, even in Slovakia, for instance, because we joined to the EU where already trademark law existed. And for instance, in my country, the office practice and also the court practice was, once the general indication is used, it covers all goods in the class, not only the alphabetical list. And back to the days, I mean, for those trademarks that has an earlier filing date than our date to accession to the EU, the IP translator case is not applicable. So we should find something again, because here we have to face with the retroactive effect. And finally, certification marks. I don't know whether I'm running out of the time or still. I still have 2 minutes. So certification marks, even though this is an optional provision in the directive, since the EU IPO has to introduce it, I think it is also clever to consider on the national level to have it. But on the other hand, there are some challenges. The first one is lack of experience. Less than 40% of the member states had something like a certification trademark so far. And the national provision in certain areas were quite divergent. That's why, especially if it comes to the content of the regulations, what is necessary to be included there. But there are some other challenges as well. For instance, the possible conflict with GI protection. Because don't forget that outside of the EU, there are some countries who think that the best way to protect the geographical indication is to use the framework, the legal framework of certification trademark. And in Europe, in order to avoid a double protection for the same subject, on the national level, it should be also taken into account to introduce subtle limitation. And furthermore, a question popped up by a number of member states where how the additional grounds for refusal and cancellation should be applied, and whether the same grounds for refusals are valid for certification trademark like for regular trademarks. Quite interesting issues. Well, from our point of view, we have an experience in this area because we introduced it in 1997. And I can tell you that the popularity of certification trademark is growing from year to year. You shouldn't expect very high number of applications, but the interest is quite high for running such trademarks, even by the state itself. So the number of applications filed by ministry and the government is also increasing. So I think this is certainly an area that's worth looking to. And finally, it has already been touched upon the fee strategy and the governance of EU IPO. I would rather just to say a few words about the fees than the governance. It was, according to the basic proposal made by the Commission, to introduce a harmonization on the structure of the fees on national level. But since national authorities are covering other IP titles than trademarks and designs, and they have also other policy considerations, therefore I think it would have not been a good and quite clever solution to interfere into the national policy of national authorities. Therefore, luckily, this was not included in the final version of the directive. And Well, this is the tentative timetable for the transposition in Hungary. Just to make it short, our idea is to start with the first draft early next year, and the final goal is to enter into force by January 2019. But the conclusions, as I said, for the non-traditional trademarks, the content of the final content of the secondary legislation might be interesting as a good guidance for us. And I think that it would be crucial to harmonize the cooperation programs, objectives, and some of the needs of national offices when it comes to transposition of the directive. And I would also encourage in the same time national member states to go beyond the minimum harmonization set by the directive and transpose more or implement more provisions, even optional ones. But don't forget that this is also an ample opportunity for member states to put into their proposal some elements that are inspired by their national needs. And this is quite obvious and I think understandable, but at the same time we shouldn't forget that this should not interfere with the basic aims of the harmonization. And with that, I would kindly thank for your attention. Thank you very much.
Thank you very much also to Imre Gonda from the Hungarian office. I'm very glad that we had the overview from all the possible aspects. I think we still have some 5 minutes for questions. So if you have some questions, this is the good time. I must apologize for Professor Kerr because of her plane. She had to leave a little bit earlier, but please feel free to give questions to our panelists. Thank you very much. Maybe I will, the time that you might reflect on a question, I have one small which might be concerning also the AYPO and also Imre from the national office. If I might ask Mr. Negrao and Imre, what is your position on the risks of cluttering of the registers at the European level? And we have been discussing the question that maybe if fees go down, it's possible that companies will go further and further to the European registry. On the other hand, we know that with the IP translator case, it was done in a way such that the consequence of cluttering would be somehow taken away, as we have more clarity maybe in services and products which were asked for, and also the new fee structure when you don't receive automatically free classes of products can go against cluttering. But I would be really interested to have the position of the national office and also the YPO on this context. I know that we have the problems in designs, but what is the position in European trademark law?
Thank you very much for the question. You might remember that, cluttering was always one of the issues discussed before the study of the Max Planck Institute, but the problem with cluttering was always the difficulty in proving or demonstrating that in fact there were issues where you would have cluttering in the register creating problems to the users. That does not mean that the register did not have a problem of cluttering, but it was difficult to demonstrate in practical terms. We have also tried on the side of the office using a number of statistical methods, because of course we are talking about high volumes and huge volumes of trademarks in the register, but in fact it was always difficult to demonstrate it. That does not mean that we should not of course take measures in order to try to avoid or reduce such phenomenon. Such phenomenon exists. I think that the regulation in this case, but also the package in general, addresses very well the issue. First of all, by proposing the one class per fee system, something that was already identified in the study, that was extensively discussed with users, and that had a broad support from the side of, let's say, the trademark community in Europe. And it would be, of course, one of the elements that would facilitate avoiding the accumulation of cluttering in the register of the EU IPO. But of course it's not the only measure that can be, of course, considered for this matter of fact. Of course, we have the IP translator decision, which is, of course, key in this context, and that helped, of course, in this case, the office to change its practice from covers all to clear and precise, in, of course, applying always the literal meaning of the class and allowing also the users to, in fact, apply for the goods and services that they, in fact, need, and not facilitating the use of large monopolies that, in fact, will, in my opinion now, because, of course, you know, this is quite a contentious issue, I think generates a lot of litigation and, of course, conflicts. I'm not sure that all of them are necessary. So I think that, on the one hand, the one class per fee was one of the important issues here, and then, of course, Article 28, not only 8, but of course 5 to 8, it's also an important legislative complement of such proposals. But of course we went one step further. We tried also with the national offices of member states to agree, once we knew the decision on the IP translator, to agree on a common practice on classification, or at least a common practice in what regards the treatment of class headings. I have to tell you that this was quite an interesting but difficult discussion, since, of course, in Europe we had for many, many years a huge split in terms of practice, more or less half of the member states having one practice, literal meaning, another half of the offices, including the European office, having a cover-all approach, and it was quite difficult, of course, to approximate these two visions, but we were able to do it in 2013. And in order to transform and to transmit these benefits to the users, we were also able to create the necessary tools that support that common practice. If you don't know, the common practice, the common guidelines that we have with the member states are published in our website and in the websites of all participating national offices. So it's something that is quite clear, it's transparent, the way we deal with class headings. But in order to help also the users in navigating through the classification, which is not something, let's say, simple, for the ordinary citizen, we have also developed with the national offices a tool that we call taxonomy, and that basically means the creation of a structure that helps and facilitates the life of the users in navigating through the NIS classification, in helping them to find exactly the goods and services that they are looking for, and that, of course, they want to apply for. That does not mean that this interferes with the NIS classification. This is, of course, something optional that should facilitate, but does not replace the NIS classification. So it's a good example of a cooperation effort done by the European countries that was also at a later stage transposed to the international sphere, WIPO, the World Intellectual Property Organization, and together the member states of the European Union were able to make a common proposal to the Committee of Experts of WIPO, on the NIS Committee of Experts, for a number of general terms of class headings that should not be considered sufficiently clear and precise to be used for classification matters. I'm sorry, it's quite extensive, but I think that this is a good example of a problematic area that was creating big and, considerable obstacles to the users in the efforts to apply for the goods and services that they really, really wanted. But of course, as a result of this cooperation effort and supported by the proposals by the European Commission that were in the end enshrined in the revised regulation, I think that the system that we have today in 2016 in terms of goods and services, it's of course much, much better than we had before 2013.
May I ask Imre on the position also, whether the feeling from the national offices is that we have the good balance about what goes through the national, what goes through the European office? Thank you very much.
Thank you. I try to make it short, and I would like to approve what has been said by Mr. Negrão, and just to try to complement, if possible. Namely, Yeah, that's true that there has not been a very clear and direct evidence of need for cluttering the register, but some feelings. That's right. And the feeling is not necessarily on the side of IPOs, but rather on the side of those users who try to create new signs, new brands. And when it comes to trademark search, it's highly difficult for them to identify new terms or new brands that are not in conflict with existing trademarks. And I know it's just a feeling, but this is the voice that I've heard usually. And of course, there are some countermeasures, I do understand, and I fully agree with that. The new fee structure, that the basic fee covers only one class, I think that's an excellent solution, but also the new interpretation of class heading, the specification issue after IP transmitter, this is also a good measure. But I would also say here, mention the use requirement, proof of use of trademarks, because I think this could be a good contra measure, and this is something that should be rather strictly and faithfully, in a faithful manner examined on both on national and also on European levels when it comes to an opposition, where this is an argument, or when it comes to a revocation based on non-use. And perhaps another issue is the fee level of cancellation and revocation procedures. I was a bit surprised when I saw the basic proposal and the end result that even though the entry fee and the renewal fee to the European system has been reduced constantly, the fee for opposition and fee for, especially for revocation based on non-use or on cancellation, has not been reduced. So it's the same since 1994, and this was something negatively surprising to me. But basically, I do understand that these measures are quite good. Well, thank you.
Thank you very much. In my view, as I see on the time that we are close to the coffee pause, so that the next panel will not be waiting too much against the schedule, maybe I would like to ask you once more to be thankful to the whole of the panel who was here, including Professor Kerr, and thank you for your participation.
Ďakujem veľmi pekne speakerom za ich opäť zaujímavé.
Thank you very much. This goes to the speakers, and thank you, Andrew, for letting the panel. We would continue in some 10 minutes, as Andrew said. The coffee break is here. It should have already started some time ago, but let's meet back at around 3:40. And that's transferability, accessibility, and territoriality in the context of a simple, single digital market. That's a very interesting thing. And please watch your time, because we've prepared something, a musical delight for you this evening. And so please watch your time and be back in 10 minutes. Thank you.
csak nem azt, szóval, hogy legyen így elrendezve, hogy
Ladies and gentlemen,
chápem, káva je horúca, na budúce spravíme asi coffee to go. To bude asi lepší nápad a budete si ju môcť vziať sem. Pred nami je tretí záverečný panel tohto dňa.
Portability, accessibility and territoriality in a single digital market. This is the topic that the experts will deal with. It will be led by Cyril van der Net, Program Director for Copyright from the Netherlands. It's in your hands.
Ladies and gentlemen, welcome back for the third and last panel of today. We will be discussing portability of online content services. We will be discussing access to information, and we will be discussing the principle of territoriality in copyright. I know that in the corridors of this conference a lot of networking has been going on, and of course this conference is perfectly suited for that end. But we also need information, food for thought, and that's what this panel is going to provide to you. Ladies and gentlemen, my name is Cyril van der Net. I'm a program director for copyright, working with the Ministry of Security and Justice in the Netherlands. And I had the pleasure of chairing the Council Working Group the first half of this year. And we intensively negotiated the proposal for a portability of online content services regulation. And we're very proud to say that the Council reached a general approach in May of this year. And we're currently awaiting the start of the trilogue. It's an honor and a pleasure to be here and to moderate this panel for you. And it's great to be here in Bratislava, the lovely city of Bratislava, the capital of Slovakia. And although it's the first time I'm here, I already feel at home. And that has everything to do with the perfect organization. So thank you very much for that. Now let us then turn to the panel. First of all, we're going to listen to a keynote speech by Maria Martin-Pratt. She doesn't need any introduction at all. She's the head of the Commission, and there are currently a lot of legislative proposals on the table. I can mention a directive, a proposal for a directive, a proposal for a regulation in the field of the Marrakesh Treaty, the treaty that has to do with the blind, the visually impaired and otherwise print-disabled persons. On the table is also a proposal for a directive for copyright in the digital single market, and on the table is also a proposal for a regulation, what I would like to call online broadcasting services, because the official title is too long for me to remember. Maria will no doubt go into the background of all the proposals that are currently on the table. After Maria presented her keynote speech, we go to the panelists, and I would like to stick to the order as they appear in the program. So after Maria, we are going to listen to Zuzana Adamova. She is head of the Institute of Intellectual Property Law and Information Technology with the Trevana University here in Slovakia. And she is also a senior associate at Petkov & Co., and that's a private law firm. And Zuzana will tackle the proposal for a directive for online broadcasting services, and she will also go into the proposal that is in the proposal for a directive on copyrights in the digital single market, and she will tackle the extended collective licensing mechanism. After Zuzana, I would like to give the floor to Igor Gilda. He's a professor of civil law at the University of Zagreb School of Law, and he's also a president of the Croatian Association for Copyright Law. And he will go into consumer expectations in the digital environment. He will go into the interest of right holders. when copyright is applied in the digital environment. So basically, he will go into the main basics of copyright. After Igor, I will, last but not least, pass the floor to Matthias Leisner. Matthias is a professor of civil law at the intellectual property law with information law and IT law with the Ludwig Maximilians University in Munich in Germany. And Matthias will go into the proposal for a directive on copyright in the digital single markets, and he will focus particularly on platforms in general and the value cap in particular. And he will also go into the proposal to create a new sui generis publishers, PRES publishers right. After I gave the floor to the speakers, I would swiftly open the discussion for you, for the participants, because we are running late, and from the organization I heard that we try to start, or we try to finish at 5:15, so there's enough room for everybody to take a shower, change clothes if necessary, and so you can all enjoy the evening program. So that's all for me. For now, I'll see that the speakers keep to the time. Let's see, Maria, you can do it probably in 20 minutes, and then we give the panelists a quarter or so. Maria, are you ready? The floor is yours.
Well, thank you, Cyril. I'll try to do it in 20 minutes. I'm known for being capable of speaking fast. And in any event, let me start by, of course, thanking the Slovak presidency and saying it's a very intriguing title for a conference, Shaping the Future of IP. I wonder who's shaping the future of IP and in which direction, but I'm sure it's something that we will need to wait a little bit to see. In the course of today and tomorrow, as Cyril was saying, you're going to hear discussions on a number of issues which are currently on the table of the Council and the Parliament. I'm not going to try to explain to you the whole of the package, because it will take me considerably more than 20 minutes, and it is probably far more interesting not to hear the Commission defending its proposal, but others attacking it, or at least analyzing it. What I'll try is to give you a general background as to the issues they are going to be discussing. When I refer to the issues they are going to be discussing, I assume what we're going to be talking about is the 5 legislative proposals that at the moment are on the table of the Council and the Parliament. And I must say is quite a large package. In my experience, this is the first time that we have to handle in parallel that number of legislative proposals. But basically, we have on the table, as you know, a regulation dealing with portability, another regulation dealing with online services or broadcasters, a directive of a more horizontal nature in the sense that it touches upon a number of different issues, and then 2 proposals, a regulation and a directive related to the implementation of the Marrakesh Treaty as regards a disability for the print disabled. So it's a large package. But before getting into it, what is the background to it? What is the large background to it? Which I think we should keep in mind to understand not only what we have put on the table, but also a little bit what we should be trying to do. There are 3 elements, in my view, which are very important in that background. The first one is that in Europe we have a complex level of harmonization, and I have carefully chosen the word complex. It's not a low level of harmonization, it's rather a high level of harmonization, but it's complex in the sense that we have now intervened, I often say partly knowingly and partly unknowingly, but we have intervened in the most important areas of copyright to the extent that the combination of the existing 10 legislative proposals with the 5 new, we will go up to 15 without counting some other existing piece of legislation like the Enforcement Directive. The combination of the existing legislation that is a body of law that has evolved over more than 20 years the very, very extensive and with a high effect case law of the Court of Justice, we have gotten to a point where the systems of copyright of the member states are very much determined at European level. And that has advantages and has disadvantages. It makes us have to move together, and it has indeed resulted in a very limited space left for member states to maneuver. Now, this, you could say, well, it's an advantage. We continue harmonizing and going towards a common system of copyright rules in Europe. It's also a challenge. It's also a challenge because, as I was saying, our harmonization is complex. And I also think there is a need to keep in mind that the reality on the ground of the member states continues to be very different. And I'm not sure whether there is a reason for that to change. But if you want what I will call the copyright infrastructure, the elements that need to exist on the ground for copyright rules to play the role they should play are very different in different member states. By that copyright infrastructure, I mean, for instance, the role of collective management, the availability of a better or less good system of enforcement, the administrative control of some of the players, even the manner in which limitations and exceptions are applied on the ground, and the role of the parties, beneficiaries and right holders when negotiating them. These realities are different, and those are in the end the ones that translate in practice for right holders and for users what copyright is about. And it is with that complex harmonization, diverse reality to some extent, that we are these days facing some rather fundamental questions. There is one which is increasingly important as we move from a system of exploitation of works that was based in goods towards one that is based in services. And that question that comes very, very quickly is territoriality. So our harmonization has been quite timid as regards territoriality. Of course, we have some fundamental elements that have been injected in the system, starting by the exhaustion of the distribution right or specific rules that have been put on the table, whether it's country of origin for satellite broadcasting, whether it is the function of the orphan works exception, or the licensing of online rights by authors collecting scientists. All these issues we have dealt with in legislation, but generally speaking, both in definition of rights as important as the making available right, or in the definition of the exceptions, the territoriality is our question mark. That is an issue that is now very much, again, on the table. Then we have exceptions and limitations, a complex matter. Whether you look them at European level or you look them at national level, a very, very difficult matter. The translation of some of the exceptions that we know in the pre-digital world to the digital world is not a straightforward one. It is not one that can be solved by saying, well, therefore, let's not have exceptions, let's rely only in licensing. I don't think a policy maker can't try to find a balance of all the interest by just taking that solution. But at the same time, one needs to be mindful that a one-to-one translation of certain exceptions offline to online might have far-reaching consequences. So it's very difficult to update exceptions. Sometimes I wish I was in the shoes of the member states, and when something as complicated as that comes to me, I could say, it's not for us to do, Brussels has to solve this issue. But the question is limitations and exceptions. Any new meaningful update or any establishment of new limitations has to be done, all of us together in Brussels. So this is the background, the complex harmonization with different national realities and difficult problems in front of us. We have spent a number of years talking about the reform of copyright. Again, I repeat myself, but that's because I speak too often. I don't like the term reform. It has a negative connotation as if the rules that are at the base of the copyright system don't work, and I challenge that. I think copyright serves the interest of many people, big and small, and our cultural realities. But one can talk rather than a reform of copyright, an update of copyright, and I think no one should have expected that we were able to do that just in one go, or that we will put now something on the table and that will be the end of all questions. That is certainly not the case. The Commission has made a big effort in the last 10 months. I mean, we have proposed 5 legislative proposals, but I am mindful of the fact that not only we need to negotiate them and get to the right result, but this does not mean that all of the questions related to copyright and its functioning in the European market and in general are going to be off the table. Actually, I am preparing myself for the Court of Justice ruling in today's time as regards whether we have or not an exception allowing libraries to do electronic lending, and in a couple of weeks as regards whether or not it's compatible with the EU acquis to have a system of compulsory collective management for works that are out of commerce. So these questions are going to be replied one way or another by the court while we are negotiating, and somehow I have the impression may become party of some of our discussions. But basically, this reality, we have taken it and we have put a package on the table which can be, if you want, divided in 3 strands, which is a number of measures where we have tried to inject more internal market to the functioning of our rules. So these are the proposals that try to help the licensing of rights and the cross-border access and portability of services. So I'm talking about the portability regulation. I'm talking about the proposed regulation as well for the online services, certain online services of broadcasters. And also you have some provisions in the directive that aim at that same access objective, notably the provisions dealing with out-of-commerce works and other protected subject matter. We have also tried to inject internal market in the exceptions because, as you will have seen, besides making them mandatory, those that we have tackled, when dealing with exceptions that affect the communication to the public / making available, we have also tried to ensure a cross-border effect, and that you find in the directive as regards the exceptions that are there, but also in the directive and the regulation dealing with the Marrakesh Treaty. So that is the first, is the internal market injection to the copyright system. The second theme is to try to take a further step for the harmonization of limitations and exceptions. Thanks. Again, this is a complex subject, and it's not as easy as sometimes you could have thought following some discussions. You sometimes got the impression that the solution for the lack of harmonization of exceptions in the European system was just basically to take the list of the 2001 directive and make them all mandatory. But that makes limited sense. Among other things, the lack of harmonization is not only because the fact that these are optional exceptions, but also that member states can implement them in a very different manner. And I think also we need to have a serious discussions as to what we need to harmonize further, what does have such an effect and importance in the internal market that merits a higher level of harmonization. We have identified a number of them. I'm not going to get into the details, but basically they relate to access to knowledge, to education and to research, including a new text and data mining exception, and of course the disabilities in the Marrakesh proposal. And then finally we have, one thing that is important there, which I think is a novelty that you need to think about very carefully. You will look into those proposals and you will see that, yes, we tried to get to a higher level of harmonization by, for instance, making them mandatory. But there is also an injection of flexibility in the proposals we have put on the table. You can see that when you look at the exception on education, but you can also see a very specific proposal that, for instance, we have put on the table in the directive to give back some flexibility for member states to organize their systems of reprography and private copying or the compensations. Some people refer to it as the reproval fix, but basically it's an exercise at European level to give back some flexibility to the member states. I think this is an important element and part of the reflection when we are going forward. And finally, yes, the third strand of measures we have put on the table, the more political and controversial ones, is a new theme. We have spent years talking about territoriality and talking about exceptions and limitations, but I think in the last 2 years, there's been an increasing request to discuss about the functioning of the online marketplace, and in some cases as well the offline marketplace, and whether there is fairness in the system. So this is often referred to as the discussions on the value gap, and again, I often have to say that, you know, there are many different value gaps depending on your point of view, but you find 3 different type of issues under this heading that I am sure will be discussed at length and are rather new in terms of intervention at union level. One is the creation of a new neighboring right for news publishers. I'm sure it will be discussed at length. Another one, in principle, is the establishment of an obligation to use technologies for hosting service providers that are providing access to large amounts of content protected by copyright to the public. It is a discussion that is going to bring in discussions related to the concept of communication to the public, one of the big incognitas in the European Union at the moment, and also the functioning of other pieces of legislation in our European acquis. And finally, a long pending issue, which I think is now going to be discussed going forward quite actively, which is what is the fair remuneration for individual creators, for the authors and the performers, which is also a difficult issue, not only because it's hard to determine what is the best way to get there, but also because often it leads to intervention in areas such as contractual law, and we know that neither member states nor very often stakeholders like us getting into contracts. That is a very, very fast background, and I'm sure the panel now and the next panel tomorrow will discuss the details. Thank you very much.
Thank you very much, Maria. Susanna, I would like to give the floor to you now.
Good afternoon. Thank you very much, Cyril. I would like to thank organizers for inviting me. I feel really proud that such an event is held in our city, in my city. And today I would like to share 3 comments regarding the portability and accessibility. My first comment deals with the legislative proposal on cross-border portability of online content services in the internal market. The other one deals with the proposal of Digital Content Directive, and the last one with specific regulation of out-of-commerce works in the proposal of Directive on Copyright in Digital Single Market and in current Slovak Copyright Act. It means that my first 2 comments will deal with the first copyright package, and the last one will deal with the second copyright package. So in December 2015, the Commission adopted a legislative proposal on cross-border portability of online content services in the internal market, as well as proposals of Digital Content Directive and Online Sales Directive. The basic idea of the regulation is to ensure that subscribers to online content services can continue using while temporarily present in another member state. At present, Europeans traveling within the EU may be cut off from online services providing films, sports broadcasting, music, e-books or games they have paid for in their home country. The proposal should address these restrictions in order to allow EU residents to travel with the digital content they have purchased or subscribed to at home. The goal of the Commission is to create the EU-wide digital single market. However, the problem is that the copyright is based on the principle of territoriality, and the copyright law allows the owner to geographically restrict a license. Right holders usually grant only national licenses to platforms in each EU member state. Where content has been licensed on a territory-by-territory basis, it is often protected by geo-blocking. The most problematic sector are the audiovisual one and the sports one, because especially audiovisual producers and organizers of sporting events usually grant exclusive license, a territorial license, to one single distributor in one member state. I share the opinion that the proposal is balanced, it's innovative and consumer-friendly, in spite of the fact that the issue of portability is quite limited. It only deals with cross-border portability of subscribers-based content services. Non-subscribers' relationships are not effective at all. However, there are still a few aspects that are interesting to observe and still need to be clarified, especially the temporary presence, the temporary stay abroad. What does it mean? The retroactivity, proof of residence, enforcement, and other aspects, but especially the question of temporary presence. What does it mean? The proposed regulation would allow content portability to subscribers who are temporarily present in a member state other than the one of their residence. However, the notion of temporality is defined nowhere in the draft of regulation. And the interpretation of the proposal should be strict, as it only applies to short-term migrants, travelers, and tourists. Regarding the Digital Content Directive, the strategy for a single digital market that was adopted by the Commission in May 2015 relates also to other legislative initiatives. Together with proposal on the regulation on portability, the proposal of Digital Content Directive and Online Sales Directive were presented. As example of subject of regulation, we can say that while Digital Content Directive will regulate contractual aspects of, for example, streaming of music, Online Sales Directive will regulate sales of music CD in the e-shop. Both directives are based on the complex set of rules, which means that EU member states will not be able to provide consumers high level of protection. It's called maximum harmonization. On one hand, the proposal of the Digital Content Directive doesn't specifically regulate the issues dealing with IP rights. On the other hand, as it relates to digital content, which is usually protected by these rights, it is connected with this topic directly, especially with copyright and related rights. The directive is lex generalis in relation to other legal instruments in the field of IP law. Any sectoral or specific regulation has a priority in case of conflict. Mostly the directive, the InfoSoc directive in relation to copyright protection and the computer program directive will apply. According to the proposal, in case of termination of the contract applies that where the digital content was not supplied on a durable medium, the consumer shall refrain from using the digital content or making it available to third parties, in particular by deleting the digital content or rendering it otherwise. Where the digital content was supplied on a durable medium, the consumer must return the durable medium to the supplier and also delete any usable copy of the digital content, render it unintelligible, or otherwise refrain from using it or making it available to third parties. The question is whether the consumer is allowed to make a private copy according to Article 5.2b of the InfoSoc Directive. Although the directive is lex specialis, making of such copy would be in conflict with the three-step test according to the Article 5.5. The proposal of Digital Content Directive also regulates that the supplier must ensure that the digital content supplied to the consumer is free of any rights of a third party, including based on intellectual property, so that the digital content can be used in accordance with the contract. This provision also deals with copyright and related rights, as it secures that the consumer will not be blocked when using digital content, and using digital content is not conditioned by acquiring extra contents from other right holders. However, in the European Parliament study, there were identified several topics that are not particularly regulated in the proposal of the directive, but could possibly be affected. Concretely, the right of consumer on multiple downloads, or the resale right to digital content, and related application of the principle of exhaustion in the digital environment. This also deals with the question whether the acquirer of digital content should also have the right for upgrades and maintenance of digital content, the resale right of digital content, and the right for acquiring necessary upgrades and maintenance deals with the Court of Justice decision USOFT. In this case, the court confirmed the exhaustion right to distribution regarding the digital copies of computer programs. However, even after the other Court of Justice decision, Art and All Posters, the opinion on possible application of exhaustion principle on other digital content than computer programs like e-books and e-music differ. I would therefore appreciate if we could finally obtain clear European guidance regarding the exhaustion right that would help consumers to effectively use their digital content. And my last comment deals with the regime of out-of-commerce works and extended collective licenses. That is regulated by the proposal, or that should be regulated by the proposal of the Directive on Copyright in the Digital Single Market. One of the key aspects how to make access to content and its licensing easier is the regulation of out-of-commerce works. It deals with such works that are still protected by copyright but are not available in traditional commercial channels. According to the proposal, the cultural and heritage institutions will be able to use out-of-commerce works from its collection for non-commercial purposes, for example, for digitization. However, it needs to obtain a license from the collective management. It is, for me, at least for me, it's interesting to see the current proposal using extended collective licenses system when we are awaiting the Court of Justice decision in the case Soulier and Doak, which will answer the question of extended collective licenses legality in European Union. And by the way, the regulation of extended collective licenses in Slovakia is extremely broad. It may be applied to any works, and you can get the consent for making available, for example, on the internet of all works through the extended license. The regulation of out-of-commerce works, which is part of Slovak Copyright Act, is also very broad. The basic setup of out-of-commerce works is that to consider work as out-of-commerce, it has to fulfill three cumulative conditions: impossibility of obtaining copies of works through classic distribution channels, such as bookstore. Work has to be placed in a library, archive, or museum, and it has to be published in a publicly accessible list of out-of-commerce works generated by Slovak National Library. The problem with the out-of-commerce system in Slovakia is especially the scope of application. It's also very broad. It's without any strict boundaries. It means that it may be applied to works published anywhere in the world. The EU proposal shall amend applicable rules which might be considered as agreeable limitation. So, looking forward for this directive. Thank you very much, and looking forward for your questions.
Thank you very much, Susanna, for your...
Zuzana, ďakujem vám za vašu prezentáciu. Igor si pripravil.
Pass the floor to you.
What should I say? Born ready or? Anyway, first of all, of course, I would like to thank you that I have opportunity to speak at this panel. Of course, I would also like to compliment the organizer both for choose such this, I think, very interesting topic, but as well as I have a possibility to be here in Bratislava, beautiful city of Bratislava, for the first time in my life. Of course, I'll also compliment the organizer for such a brilliant organization and smooth going conference. Our topic is shaping the future of IP. So as Maria already mentioned, we don't know who will do this. But whoever it will be, I believe that he, she, or they, I don't know who, must remember what is, when we're talking about copyright, what is copyright all about. At least in continental part of Europe, the main reason for copyright, and also the justification of a copyright, is protection of the creator interest, both economic and moral. This means that the author should be able to control his work, so meaning that he shall be able to decide whether his work will be used or not, in what manner, under what condition, and who will allow to use the work. In this light, I believe that the main idea is the same like the owner has over his thing in material world. So as the owner traditionally is able to decide who will control, who will use his thing, and if anybody else will, other than him, use this work or not. I think that the author should have the same right like the owner on material thing has. So let me recall in that manner on the words from the very beginning of the copyright era, from the 18th century, of the great French lawyer Le Chapelier. He said that the right of the author is the most sacred, the most legitimate, and the most undeniable of all property. La plus sacre, la plus légitime, et la plus inattaquable, et la plus personnelle de toutes les propriétés. I think that we should really have in mind these words when we're talking about copyright. And I think that the sounds of these words are loud, very strong on the beginning of the creation of the acquis communautaire in the field of copyright, which was beginning, or which was not just beginning, but the whole 19th and the very beginning of of last century and the very beginning of this century. The whole approach was pretty, I could say, authors-oriented. However, I think that this course has changed. And now, when we're speaking about the copyright, the main words are not protection of the author. The main words are balance of interest, consumers' rights, new technologies, creative users, freedom of expression and information, limitations and exceptions. So it seems that the point of interest has shifted from author to the consumer and industry. Also, the starting point of every today's discussion of the modernization of a copyright is technological possibilities, technological development, and similar. It seems to me that this technological environment, in technological environment is often forgotten that behind every work is the author. And in my opinion, the key issue of the modernization should not be the conflict of interest between industry and consumers, but in focus should be the author. I know that's very true that in this whole process of technologization of the whole society and accordingly the copyright, which is pretty complicated, and the numbers of stakeholders when talking today about the copyright is really huge. So, and while taking account all of the interest of all of these stakeholders, it's really easy to lose the creator as an individual. Therefore, at least in my opinion, when talking about the modernization, the focus should be on finding the solution to protect the creator as the probably weakest side in all of this system. So, in my opinion, that means that the whole system, whole modernization should be more creator, authors-oriented, and less economic-oriented. That's true that the other weak side of this story is consumers. The problem is that consumers often see the copyright as some kind of the obstacle to their consumers' right, and I must say that I put these rights under the question marks because I'm not quite sure if there really exists something of the consumer's right, especially when we're talking about the copyright. But on the other hand, these obstacles, regular consumers does not feel as these obstacles are in favor of their idols, the authors, and so on, performers. But I think that they usually have impression that this obstacle is only in favor of industries. However, nevertheless, that consumers' perspective is not very objective usually, and it's of course very self-oriented. Sometimes, or of course, there are some expectation that's quite reasonable. One of these expectations that I find reasonable is expectation that they could have, the consumers, they decided to switch from analog to digital world, which is more or less all young people. Some reasonable expectation is they have the access to the copyright content like wherever they are, like they have at home. So this is the question of the portability. So meaning that probably will not be good to restrict the consumers only with the fact that they move from the house, and they should find some solution that they even if their consumers are mobile, they could have access to their works. The problem is that in single market, why this problem arises at all? Because in single markets, in whole single markets, they are not possible to access to the whole online services. So there are some markets on which online services does not exist at all. So even those, they have legitimate access to the online service when moved permanently or not permanently to the parts of the markets, internal markets that are not covered with this online service, so they lose this opportunity for the access. Of course, this is not only the question of a copyright, or basically this is not the question of a copyright, but of the regulation of the whole market. But anyway, besides this problem is also the problem of kind of discrimination of the consumers which are not in the internal market, which not belongs to the market which is covered by this online service. Regarding the creators, I think that their basic interest is to control the use of their creation. Bearing that in mind, it should not be allowed, at least in my opinion, regardless if there is a massive or individual use, that the creation, that the use of their creation is allowed without their authorization by limitation or exception, which is established in the name of some other social interest or social values, including the development of the market or access to the information and like. So usually behind all of these values, social values and interests, is often the profit, which is of course justifiable. But on the other hand, in creating of this profit, usually the portion of a value of the intellectual creations, it is not calculated. So when we are talking about the promotion of these values, I think that we could not go so far that we encourage the new usage of a copyright works with no possibility for the author to prevent such uses. In that sense, I think that is not justifiable to allow entrepreneurs, even if we are talking about the small and medium enterprises, who founded a business on the use of intellectual creation of others, not their own, to acquire the benefit on the expenses of the creators. I think that we should not encourage the free riding of some else horses as a principle, because at the end of the day, this is contrary to some fundamental principles of private law, which copyright certainly is, so that recognize the protection from the unjust enrichment, or so-called conditio sine causa. In that sense, I believe that minimum that we should provide to the author, even in mass uses, is that the authorization for this respective use is provided by the collective management society, which should be authorized to provide the conditions for use on behalf of all members. Regarding the collective management, I think that collective management is also quite restrictive for the individuals. Regardless of the fact that collective management has certainly contributed a lot to the better position of the creators by making them possible to exercise the right that without collective management system is not able to do. But on the other hand, we must also think about this, that the individuals with the system of the collective management just lose the possibility to control their work, and in exchange to only remuneration that the collective management society find appropriate. Also, my final words will be regarding the question of the multi-territorial license. With the multi-territorials, if we're talking about internal market, single market, the multi-territorial license is certainly good for at least for the users. However, I find that in some cases multi-territorial licenses could be danger for the authors and other creators from the let's say member states, small member states like, for example, is our host Slovakia is, or Czech Republic, or Croatia, Slovenia, Hungary, and so on. So, because usually that the works of the authors from these countries are not interesting for on the international level, even because of the language, because these languages are not spoken by many people, or because they deal with some specific, with some issues which is specific for these small markets. So I think that in that case should be find some solution or find some mechanism to prevent that in the mass of much more internationally interesting works, that these works are not lose the value they have now in exercising copyright by on the national level. So they should be prevented in a manner that they not be forgotten in all of this mess. Thank you for your attention.
Thank you very much, Igor. And the last speaker on the list is Matthias. Matthias, the floor is yours.
Thanks very much, Cyril. Now, I, for one, wasn't surprised how beautiful Bratislava is. I've been here 20 years ago, exactly 20 years ago, by bicycle. And when I arrived today at 6:30, I was quite happy that I didn't come by bike this time because it was so cold. But I can assure you that it is beautiful in fall as well as in summer. It is a beautiful city, and I thank you very much for the invitation and for the occasion to share some ideas, to listen to you, and to discuss the Commission's copyright package. And I think the presentations complement quite well on that panel, because after having given the broad overview and dug a little bit deeper into some issues of extended collective licensing and having covered the basics, I want to drill a little bit deeper into two other issues mainly, and that is dealing with the online content platforms on the one hand, and the proposal on the new neighboring right for press publishers on the other. I think that these are two elements which are crucial for the accessibility in the digital single market and for a search for balanced and reasonable solutions. And as we will see, I am skeptic of whether these goals can really be reached without perhaps being a little bit more courageous than the current proposals. I will focus, of course, on the Copyright in the Digital Single Market Directive proposal, and I would also like to share some prelim ideas for a broader revision of the system, although, of course, I know that we also have to establish the political will for that, but we're going into the negotiations in the Council now, and this might not be the end of the story with regard to these broader ideas. So let's first discuss very briefly the proposed negotiation mechanism in Article 10 for video on demand platforms that basically amounts to an obligation of the member states in the future to establish a negotiation mechanisms in order to facilitate licensing on VOD platforms. I think on a technical level it might be recommendable to further specify what a VOD platform in that sense is, because depending on the technical particularities, depending on the technical design, some of these platforms might be covered, some of them might not. There is also a lot of different licenses in the market covering different situations here. And I think a definition in the text of the directive might be recommendable in that regard. However, even such a definition will certainly face a problem, which is a red thread which goes through my presentation, and that is, of course, that as long as we haven't dealt comprehensively with the rights situation, it will be very hard to achieve harmonization and effective licensing in the single market on the basis of merely facilitating the negotiation processes. And that, of course, brings us to the large terra incognita of European copyright law at the moment. In other times, one would have said that's where the lions are, hic sunt leones, and that is the ECJ's case law on the right of communication to the public with regard to internet users. Currently, the legal situation in that regard is at best unclear, and I don't think that is particularly problematic with regard to the negotiation mechanism according to Article 10. A proper definition of VOD platforms could solve that problem, because I don't think there is a serious doubt in that field that they touch upon certain exclusive copyrights. But of course it is a more general problem, as I will try to show throughout my presentation. And that also concerns the press publishers remarkably. It's somewhere down on that slide. But as for the press publishers, I'd rather discuss that from a somewhat more fundamental perspective. And that is because we have some experience with a neighboring right for press publishers in Germany. And I think, well, at least all academics in Germany, and also a large part of the stakeholders in the markets would agree with my analysis that this hasn't been a success story yet. We have introduced a new exclusive right for press publishers. The result of this was within weeks that the major press publishers in Germany, including the largest tabloid press publisher, Springer Company, licensed their contents to Google for free. So it was a for free license, whereas the collecting society specialized in the field rather approached smaller and medium-sized platforms, negotiating them into more or less disadvantageous deals, because these smaller platforms didn't have the resources to act like Google. They didn't have the market dominance such as Google in order to negotiate the new exclusive right away. Another outcome we have all seen in Spain. It seems to me equally problematic, and that is that Google simply shut down his news service when a new remuneration claim was introduced in the Spanish market. That at least leaves me skeptical at the outset of whether such new exclusive right will help remedy the situation. And I share your view on the problems we have, and which also not all the academics in the field do, but I think some other solutions might be more appropriate, even for the press publishers, to reach their, from my point of view, partly justified goals. So first, I'm of the opinion that such new exclusive right would disadvantage smaller platforms. I've tried to illustrate that with a German example. A large market-dominant platform will be in a position to negotiate the right away. Smaller newcomers to the markets will hardly be able to do so. So that might increase certain structural competition law problems in the markets for internet content platforms, which are characterized by the existence of certain dominant market players anyway. What is even more interesting might be the overall impact on the traffic on press publications' internet sites and the redistribution effects this might have. As for the overall impact on the traffic, there has been a PhD study commissioned in my institute, which basically said, well, this might even be a complementary service being useful in the end of the day for these sites. Why else should they have licensed this away to Google for free? But then, of course, you could still say, but there is the value gap, they should get a share. Still, the overall impact is a thing we should analyze further. But what is more interesting is that news aggregators have a certain redistributional effect, which, as far as I can see, and the PhD study in my institute has at least quoted the economic papers on this, which results in basically redistributing traffic from large national press companies to smaller, specialized local press companies. So small companies will be advantaged by these news aggregators because their traffic can be reached more easily. So a new exclusive right for press publishers, basically intervening with these markets, might, if news aggregators shut down as a result of this, even be disadvantageous for the structure of the press market, basically helping the large players in the market while disadvantaging the small press undertakings. From my point of view, and I don't have the time to go further into that, but in result, from my point of view, some of the problems we can diagnose here probably rather follow from the market structure in the platform market, characterized by some dominant players, and that might indeed rather be a problem for competition law, area-specific competition law, media-specific competition law on the internet to solve these issues. However, of course, some problems in the market can't be denied, and we could ask the question from a more practical perspective of whether the new proposed exclusive right would solve these problems. Well, even compared to our new press publishers' right in Germany, I think at the moment, arguably, the right according to the directive is remarkably broadly defined and not limited with regard to the protected subject matter. Even in the database directive of '96, we have a provision which says only substantial parts of databases will be protected. The German legislator said at least it must be more than 3-4 words. Nothing like this in it. We would have defined that along the lines of what is really protected here. Is it the investment? Is it setting this down typographically? Is it the reputation of the press undertaking? That will be very hard to define if we don't specify that further in the text of the directive, so that would certainly lead to problems. And what is more, here again, the fact comes into play that the right of communication to the public isn't effectively harmonized on the EU level. And if I look into the ECJ's judgments in Svensson and Bestwater, what I derive from this is that with regard to material which is published without technical restrictions on the internet, such as the typical materials of press publishers, at least the new right won't trigger a public communication to the public anyway, because no new public will be reached on the internet, and therefore the very right would be quite useless with regard to the communication to the public right. We had the same problem in Germany. Some have argued for a split interpretation, interpreting the new right in a more traditional German kind of way. But that solution isn't open on the European level, so what remains is basically the reproduction right. And as soon as technical solutions were found which avoid reproductions being carried out in the EU market by the news aggregators, the new right at the moment, if we don't fix the uncertainties with regard to the communication to the public, from my personal point of view, might even be useless. I'm not sure of whether the press publishers have noticed, but at least this is what some of my learned colleagues from Germany, such as Alexander Peukert and others, would agree with. And we've discussed this extensively, of course. I think even from the viewpoint of the press publishers, some alternative roads might be preferable in order to reach their partly justified goals. I don't think an exclusive right will reach their goals in the first place. I do think that area-specific approaches in competition law should be considered. And I think we should think further about a remuneration claim assigned to the press publishers in some form or the other, which then at the same time could be a first step into further aligning the system of remuneration in the different member states, and therefore could also be a little piece in the jigsaw to complete the harmonization of copyright law with regard to collective remuneration on the EU level as well. I think that should be the discussion we should lead, and honestly I was surprised that it seems that the press publishers indeed rather wanted an exclusive right than a remuneration claim, which even for their goals might be more useful from my personal point of view. And then, of course, if we discussed on the basis of the current proposal, we would have to clarify further issues such as the scope of the new right, and in particular, I think we would have to protect individual authors more effectively against disadvantageous effects of the new neighboring right. In particular, it should be clarified that also with regard to possible collective rights remuneration claims, which could also be put on top of the new proposed exclusive right, this should not work at the disadvantage of the individual authors, because you have to consider, with regard to most of the remuneration claims in the member states, the amounts coming from collective remuneration mostly are subject to a cap anyway. So it's basically all about distribution. And if a new neighboring right comes in, the danger that this might work at the disadvantage of the individual authors is imminent, and this should be clarified in the proposal from my point of view. And now it doesn't come as a surprise that my preliminary result will be very similar with regard to online platforms. The new Article 13 on online platforms, from my point of view, is an important step into the right direction, and I will illustrate this to you with an example from Germany. What the Commission proposes is further cooperation between right holders and hosting platforms. The platforms shall provide for an appropriate and proportionate measures such as effective content recognition and the like. And this, of course, has to be read with recital 38 of the directive proposal, which at least in the English text seems to imply that a structured host-providing platform such as YouTube, for example, might be an infringer with regard to the communication to the public right. The German text of the directive is much more ambiguous in that regard, and the case law of the ECJ hasn't clarified that issue yet. But the proposal of recital 38 together with Article 13, at least in Germany, resulted in the end of a more than a decade-long battle before the German courts between German collecting society GEMA and YouTube. GEMA, as the only collecting society in the European market, had never licensed YouTube. And my personal analysis would be that YouTube and Google, let's put that rather bluntly, were so scared by that ongoing legislative process that indeed they were prepared to cooperate further in that regard. And now we have a licensing agreement in Germany, although unfortunately neither of us knows what's in it, because of course it is overall protected by comprehensive NDAs. The fundamental problem which remains is that the proposal attempts to establish a cooperation procedure with regard to the obligations of the platforms, notably, without tackling the issue to further define the scope of the right of communication to the public and to take into account the differences in the framework of accessory liability, as mentioned this morning by Mr. Justice Arnold. And from my point of view, from a very fundamental perspective, I doubt of whether an effective cooperation mechanism can be established in the different member states without knowing the baseline of what the mandatory obligations of the platforms are. Actually, my suspicion would be that these cooperative negotiation procedures will, in different member states, lead the platforms to do exactly what they have to do under different member states' laws. That's what we've seen for years. They will do what they have to do, and that will depend on member states' laws unless we try to tackle the issue of the communication to the public right and the obligations of the platforms in the framework of accessory liability as well. So I think one might be even more courageous instead of the attempt to clarify the InfoSoc directive without touching it. I think it might indeed be considered to revise and reform the Information Society Directive with regard to the communication to the public right and with regard to accessory liability. And I think at least this should be triggered specifically by specific problems which the ECJ judgments in GS Media and in McFadden as well might pose in the future. These, of course, couldn't be taken into account in the proposals of the Commission comprehensively because they are very recent. And at least the ECJ's judgment in GS Media is very problematic, which is the last point I want to make here tonight, because I'm totally aware that I'm the only person standing between you and a quick shower in your hotel rooms. Actually, what the problem of the GS Media judgment is, that it regards commercial link setters as liable for a copyright infringement on the assumption that they had knowledge that some material they linked to was illegally on the internet, and that this assumption can only be rebutted if the link setter shows that he complied with all the reasonable duties of care. Now, that is not such a bad solution. It could lead to balanced solutions, but of course, it very much hinges on what the reasonable duty of care is in different areas. Necessarily, it can't be the same for a search engine linking to thousands and 10,000s of contents on the net. From my point of view, it is even arguable of whether the judgment really covers search engines as a service, because it could be argued that the judgment only covers manually posted links. But if search engines were covered, the duty of care should be reduced very much. And that, of course, could be done by the member states' courts on the basis of GS Media. But from my point of view, we wouldn't reach effective harmonization in that regard. So the whole possibility to reach a balanced solution with regard to hyperlinking on the internet, which really is a fundamental technique for the internet infrastructure, at the moment being hinges with the different member states' courts specifying the framework, the rather broadly formulated framework of the GS Media judgment, at best, if it isn't very much damaged by the GS Media judgment as such already. And that is why, at least in that specific area, we really have a specific and imminent reason to do more than what is proposed in the copyright directive in the single market proposal of the Commission. And I think we should deal with that and should tackle these issues in the Council, which brings me to the end. The possible ways ahead in the negotiations in the Council, from my point of view at least, should comprise a specific path, let's say in a rather quick and dirty language, what might be called by policy players a GS Media fix, perhaps a McFadden fix, and some other smaller odds and ends I just would like to mention here, such as aligning the exceptions of the database sui generis right with the general exceptions in copyright. We should really do that. And what we should consider, but that is rather covered by another speech here, with regard to the new contract law instrument, there should be a direct claim for appropriate remuneration for the authors, but that is a different topic. I don't want to touch upon that here. And we should consider a more general path would be to tackle comprehensive reform of the right of communication to the public and the framework of accessory liability for intermediaries. That is what Mr. Justice Arnold energetically requested this morning, and I'm energetically with him with regard to that issue, and don't hesitate to repeat him once more, although that costs even more time of my precious speech. And I would have some proposals on these issues, but that, of course, will have to be left for another occasion. At least Maria Martin-Pratt and I will meet next Monday in Berlin in a further platform conference. And as you see, this is already the advertisement block, and that's the end. Thank you very much for your attention.
Ladies and gentlemen.